everybody. I declare this this public hearing of the Standing Committee on Employment, Workplace Relations, Skills and Training for its inquiry into the operation and adequacy of the National Employment Standards. Start with some introductions. I'm Karina Garland, I'm the member for Chisholm and I'm the chair of this committee.
And I'm Ash Amby-Hapar, the federal member for Barton, based in Sydney.
And I believe we've got someone on the phone. Ms Roberts?
We have Chair Tracy Roberts, federal member for PS, Western Australia.
Thank you very much. I begin by acknowledging the traditional custodians of the land on which we meet today and pay my respects to their elders past and present. I also extend that respect to any Aboriginal and Torres Strait Islander peoples joining us today. In accordance with the committee's resolution, this hearing will be broadcast on the Parliament's website and the proof and official transcripts of proceedings will also be published on the Parliament's website. I remind all present that as Chair I will ensure that proceedings are conducted in an orderly, respectful and courteous way. Those present here today are advised that filming and recording are permitted during the hearing. I remind members of the media who may be present or listening online of the need to fairly and accurately report the proceedings of the committee. I now welcome the Australian Small Business and Family Enterprise Ombudsman to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Linda Makalari-Smith, the Australian Small Business and Family Enterprise Ombudsman.
And Aidan Storer, the Executive Director of Policy and Advocacy at the Office of the Australian Small Business and Family Enterprise Ombudsman.
Thank you so much. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you for the opportunity to address the committee today. You've received our submission with respect to the operation of the National Employment Standards. I just wanted to, before we dive into questions, I just wanted to briefly acknowledge the particular challenges of small businesses in navigating the complexity of the industrial relations system in Australia. The National Employment Standards is, of course, a critical component of that, but it's not only the NES, it's its intersection with the industrial instruments that apply in workplaces as well. So I'm very happy to take the committee's questions.
Excellent. All right, well, I may begin with some of those questions before throwing to some of my colleagues. Look, we've heard we've read your evidence and we've heard from a number of people already who, have said that consistency is really important and that has an impact on compliance. So I just really invite your reflections on that.
Yes, I would certainly endorse that position. I think, and in the natural operating environment of the small businesses, it's not only changes that might happen within an employment context, but it's also more broadly. So with our small businesses at the moment, they're grappling with a number of changes. So, and obviously there have been significant changes in relation to workplace relations over quite some period of time. And in addition, we have payday super coming in from the 1st of July, which broadly everyone's very supportive of, but it is obviously a challenge from an administrative and process point of view and cash flow. You've got the decisions from the RBA around surcharging as well. You have the transition of youth wages in the retail sector for those who are over 18 as well too. So any consideration of changes with respect to the NES, I would just caution in terms of the capacity and capability of businesses to actually be able to absorb that and apply it. And of course, a number of our small businesses, in fact, most of our small businesses would be covered by modern awards as well too. So the NES is obviously a really important component, but they're grappling with the application of the modern awards as well.
Yeah, and I think on that point, to sort of draw things out a bit and to, I think, reflect on your submission too around, talking about a positive educational partnership. I mean, something we've heard a little bit so far is that when changes are made, people are not necessarily aware of those changes in terms of the industrial relations legislation. So just on that point, thinking about what information, education, etc., do you think would be helpful for your members? Like, how do you engage with small businesses already?
Yes.
And I guess as the Ombudsman, obviously you have a particular role to play, as in terms of the outreach as well. How does that happen? What are the gaps? Where is the non-compliance happening? And how could we improve that?
Great, thank you. So in terms of the services that we provide, we've got a website where we have a lot of information available across a whole range of small business issues, and we've also got a contact centre where people can actually call us. We also provide assistance where a small business is in dispute with either another business if it's covered constitutionally, or with departments or entities related to the Commonwealth as well too. A lot of our outreach is connecting with a whole range of different stakeholders, so small businesses of course actually themselves, but also through industry associations, local chambers of commerce, other networks within the Commonwealth, where there's people on the ground in different, particularly in regional areas, in different communities as well, and there's opportunities around even at the local government level. One of the things we always come to is where are small businesses just naturally doing their work, and what are their natural business operating systems. So rather than requiring businesses to have to know about necessarily everything and know where to go and the websites and the like, how can we actually reach deeply into small businesses? We're pretty active in the social media space in terms of trying to communicate with businesses through that way, and trusted advisors are a really important pathway. So accountants, bookkeepers, lawyers. Most small businesses will have at least one of those, if not all of those, and they're people they trust and who understand their particular context of their own business. So with any sort of thoughts around education activities, I think going to where small businesses are already getting their advice. One of the challenges is there's actually no shortage of information and support and advice for small businesses across a whole range of things, across all three levels of government, but the challenge possibly comes because there's so much of it. Where do you actually start? So different agencies will have their own material, and it's beholden on a small business to know I might need to look at ASIC's website, I've got to look at Fair Work Ombudsman's website, I might need to look at Fair Work Commission's website. So I think the more that we can actually go to where small businesses are running their business and operating, and where they're getting their advice from that works for their business, and hooking into that rather than expecting small businesses to have to come to government for advice.
So it's that outreach. I mean, we've actually heard a little bit about accountants being pretty critical in the advice that they're able to offer their clients in small business. So
Can I just add one comment? Just adding on to thinking
please.
about education and guidance, it's also important to remember that small businesses are incredibly diverse.
Yes.
So there's not one size fits all approach to education and guidance. You've got different cohorts. I mean, we talked about called businesses. We've got a whole variety of businesses. So really thinking about how do you actually, and also I think given the time poor nature, how do you go to them, meet them where they're at, and in thinking about that, how do you provide information, education in different forms that can be digested in different ways. We've often heard from small business stakeholders that face-to-face type, rather than lots of passive reading of lots of written information, is often a more effective way. So thinking about, are there opportunities there to actually meet the needs of those, the way that they consume information within the restrictions that they have around their time-limited nature as well, is really important.
So I guess just to reflect on some of your responses so far, would you say the gaps are, not having, the full swathe of options in terms of getting out to meet people where they're at? And I guess, again, like trying to understand where those non-compliance areas seem to be in terms of what are the common areas where small businesses are not potentially meeting their obligations.
I think there's a couple of things that we would see from our conversations with small businesses that they grapple with. First of all is knowing what applies. So which modern award applies, and in some businesses and with different staff, you might have multiple industrial instruments that apply in your workplace. So there's complexity with that. There's then complexity around potential employment status and casual conversion potentially as well. and then there's complexity around implementing wage rates. So particularly if you work outside maybe standard hours. So if you've got a 9-to-5 business, that's probably less of a challenge, like Monday to Friday. But if you're working across different hours, different days of the week, operating on public holidays, that can be challenging as well in terms of knowing and all the various different wage rates that actually apply that could apply in a particular business, and staying up to date, of course, as well with annual wage reviews as well. There can also be some challenges around record keeping as well, the record keeping that's required. In our experience talking to small businesses, if there's missteps in terms of employee entitlements, often it's inadvertent. It's either they didn't know that they were meant to do something, or that they've tried, and a common thing that we would hear from small businesses is loaded up rates. So they find penalty rates very confusing, so they sit and they have a bit of a go about, well, if I pay my staff extra for a particular hourly rate, that should hopefully cover off penalty rates, and they can run into trouble then if that on balance doesn't actually work out. And of course, some modern awards don't actually allow that. Or there's very formal ways. If you do it, there's a very, very formal way where you need to do. So in hospitality, for example, you've got to do annual reconciliations. If you pay an annualised salary in hospitality, it's actually more record keeping and work than if you paid them on an hourly basis. So that would be some of the challenges as well.
Yeah. Something we've heard as well as been some confusion around parental leave provisions across a number of businesses, and I'm just wondering if that has come up as an issue with the people that you're working with.
I think it comes up in a couple of different ways, and in leave more broadly as well too. Yeah. And sometimes, particularly when it comes to certain types of leave, and I'd include parental leave and family and domestic violence leave in this, sometimes a nervousness of small businesses not wanting to say the wrong thing to their staff, and being nervous about, well, if they say the wrong thing, if they use the wrong language, will they then be exposing themselves to a discrimination complaint as well? So we would hear those sorts of perspectives from small businesses. And in terms of parental leave, around eligibility and how it actually works in practice, and then also return to work as well after parental leave, and that can be really difficult for small businesses to even navigate. And in practice, and if they are in a position to replace someone while they're on parental leave, ensuring that that's done in the appropriate way, and then that person's being exited for the person to return from parental leave. And then if you have a staff member for whom they might be entitled to special leave during the course of their pregnancy because of pregnancy-related issues, small businesses not necessarily being across all of that, and because they don't have dedicated HR or IR expertise, or it's expensive to buy in. One service which we hear very positive things about, and I think there can be more opportunities to promote this, is a service that the Fair Work Ombudsman provides for. Basically, the Fair Work Ombudsman provides subsidised legal service via legal firms, where small businesses can actually get written legal advice around tricky questions that they might have in respect to the Fair Work Act. And the feedback that I have from businesses who've used that is fantastic. So I think anything that we can do to shine a light on that, so businesses know, because that's an existing service that is available from the Fair Work Ombudsman, which can be tailored to small business needs. So that's, in terms of when you're thinking about educational opportunities, that's an existing service that works well. But I think there's an opportunity for more small businesses to know about it.
So just ensuring that they're aware that they can access that.
That's right. Yeah, that's right. And also how it's pitched as well, because small businesses are naturally a bit nervous about talking to regulators. And that, the ATO grapples with the same thing as well. So small businesses might be a bit hesitant potentially to go to the Fair Work Ombudsman to say, hey, I've got a problem. I'm not sure I've done the right thing here. Can I get some legal advice? Because they're concerned that, will they then have, workplace inspectors racing out to see them the next day. So any assurances that can be provided from Fair Work Ombudsman that they have this service, that it's a safe space to use it, I think would be very impactful.
Thank you. I might see if my colleagues have questions.
Yeah, I just have, I think you've asked a number of questions I've already wanted to ask, but I think through you, Chair, So my background, I worked at the AHA and also for a number of unions. So this is kind of my jam, and I understand some of the challenges with compliance, particularly for small businesses. I think it's more. Would love to hear your reflections or your thoughts around at what point, if someone is considering to start up a small business or whatnot, in a sense of, I guess, educating themselves before going to that process. And I say that because I've had the privilege to be able to do operational aspects as well at St Vincent's de Paul, and with my background was able to correct a lot of things to make sure it's compliant.
Yes.
And obviously that was quite beneficial. So I'd like to hear from you guys what you think, if that's something that needs to be taken into consideration.
Yeah, I think there are great opportunities in that space. It's getting the timing right. So when we look at communicating and educating, providing services to small businesses, and going to Aidan's point that they're so diverse as well, is what's the right point where a small business is open to learning about something, and the right point where it's at the right timing so they'll retain that information as well. And it's one of the challenges, and I know there's been conversations over the years at the point at which you register your ABN or you incorporate, should a small business get sent a whole heap of information about everything to do with running a business, including potentially employing people. I think that the challenge with that is most small businesses start out firstly as sole traders, incorporated or otherwise. So the right point is kind of at that juncture when they're looking to employ their first person. Because I think the challenges, there's a bigger challenge for a small business going from being a non-employing entity to employing your first employee than, for example, going from your first employee to maybe your fifth employee. So that jump from 0 to 1 is quite significant. So if there's ways in which when small businesses are thinking about that growth stage and they're wanting to bring people on to work for them, the other flip side as well is some small business owners don't start their own business, they purchase another business. So if you're purchasing another business, you might be inheriting an existing workforce, and we see that in franchising a lot as well too. And so I think opportunities around business purchase as well, if it's an employing entity, could be a good opportunity as well, because you might go from not being an employee yourself to then buying a business, and all of a sudden on your Friday you're an employee and the Monday you could be employing 20 people, and there's no ramp up to that in terms of learning how you need to meet your workplace obligations as well too. So and again in the sort of natural business system. So I know Fair Work Ombudsman and Fair Work Commission are working through at the moment how do they connect their incredible data sources as sources of truth into the business software, for example. So when a business is using their business software to run their business, if they were able to record the hours that their staff are working or even do rosters through that, and it's connected into an authoritative source of what wage rates are, then the ability to your system to be able to say, well, if Aidan's working these hours this week, this is what the wages are going to be. And then I think there's great opportunities in that space, but I really think it's been really, really precise around the just in time at that point when they need the information.
And can I add one risk that we're hearing a bit about is we've heard instances of where a small business is looking for information maybe about what an applicable award rate is for someone they're about to bring on. They're going to open AI tools, which obviously has a very, it scrapes from everything it's on the web. So there's some real risks around, and getting obviously information back that's, they'll get multiple answers. Often they'll even we've heard stories of awards that don't even exist that actually appear on those searches. So again, if businesses or business owners are increasingly resorting to those sorts of tools because they're quick, they're cheap, or they're free in many cases, it's thinking about how can we use the capability of AI tools, but do it in a way that they're only gathering information from trusted sources. So more sort of closed AI tools is something that I think would be really valuable.
So it sounds like there's lots of ways people can find information, and not all of them are accurate and
Absolutely.
reliable. Yeah,
that's right. And sometimes that's from fellow business people as well too, in terms of when you're talking to others in industry or family and friends, and the complexity of figuring out what your industrial relations obligations. It's just complex. So getting it from someone who actually is the authority on it is actually really, really important.
And on that note, obviously, you're a very important source of information and assistance for small businesses. How do small businesses and family businesses find out about you and your work?
Yes, well, that is a challenge we also grapple with in terms of, again, getting the messaging out. So they'll come to us in a couple of different ways. So that you've obviously got business.gov.au that is a repository of a whole heap of Commonwealth information. We've got close relationships with all the states which have state-based small business commissions, and the way that we sort of collectively take that challenge is wrong front door. So if someone comes to, say, the Victorian Small Business Commission, and it's actually a matter for us making sure that's a warm transfer across to us, and us referring on to other states if it's not within our jurisdiction. But it's a challenge we have. So we've got newsletters, we've got great content on our website. As I said, we're active in the social media space, and there's more we can do in that space as well about getting the messaging out, and also through what we've historically done is through industry associations, chambers of commerce. One of my priorities coming in as the new Ombudsman is really focusing on businesses who aren't connected into other groups, so who aren't members of chambers, aren't members of sectorial associations and the like, and particularly those in remote and rural and regional communities as well. So what we'll be doing is exploring, well, how do we do that in the best way? And that might be through local council connections across the country. There's also a number of Commonwealth agencies, and Oz Industries One, who've got people in different towns around the country. So how do we actually connect into where small businesses are already naturally operating? Because the feedback we get from the businesses we help is brilliant, but they need to know about us to know that we're here to help.
Yeah, and on that as well, I think in terms of that information and outreach, something we've heard a little bit about so far in this inquiry has been, we've got a lot of, very diverse country. We've got a lot of businesses that are run by people who English may not be their first language, and it may not be the language they're most comfortable reading, particularly, legal style information. So do you have programs to engage with people who may not have English as their first language?
We ourselves don't have formal programs. Where we have specific initiatives we're working on, it might be in partnership with those who do. And I definitely think there's more we can do. Absolutely in that space. And one of the things we're looking at doing is we're reviewing our website and how information, the content on there, and also so we use the translation service, for example. We use TIS, if we've got a phone call we need to. Also from a dispute resolution perspective. So if we've organised a mediation and someone needs a translator, that we would organise that at our cost, not at the small business's cost. But I think there's absolutely more we can do in that space.
Great, thank you. Did you have any further questions?
No, Chair. Thank you.
No. And I'll just double check that Ms. Roberts doesn't have any questions. Okay, thank you. Thank you very much. Well, thank you so much for your attendance here today. You'll be sent a copy of the transcript to request any required corrections, and enjoy the rest of your Friday.
Fantastic.
Thank you.
Thanks very much.
Yeah, thank you.
Thanks.
Sorry, take your time.
Putting in there. Giving my advice, I think I was doing quite, if you don't mind.
It's a bit earlier. Good morning, how are you? Good. do my little preamble first. Yep, excellent. Thank you. I now welcome the Council of Small Business Organisations Australia to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Michael Gerard Summerton. I'm the Head of Industrial Relations for the Council of Small Business Organisations of Australia. Yeah.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair. It will be brief, but I thank you for the opportunity to appear on behalf of COSBOA. As you know, we are the national peak body for small business in Australia. We represent the interests of small business across all industry sectors, and I'm sure you're very well aware that small businesses make up 97% of all Australian businesses, employing 5 million workers. COSBOA's position in relation to the National Employment Standards Review is that further change to the National Employment Standards is not required at this time. That is not because small businesses oppose fair and reasonable employment standards. We do not. We understand and support the role of the NES in protecting workers and establishing a clear baseline for the employment relationship. COSBOA's concern is one of timing, capacity and cumulative impact. Since 2022, small businesses have been subjected to a very significant rewriting of Australia's Workplace Relations Framework. The Secure Jobs Better Pay Act, the subsequent Closing Loopholes Acts, Parts 1 and 2, have introduced over 38 substantive amendments to the Fair Work Act. Only one of them does not apply to a small business concerning multi-employer bargaining. So all of them relate to a small business, whether they're a 5-person baker or a $100,000 corporation. Each of these have arrived with new compliance obligations, new Fair Work Commission jurisdictions, and of course, new legal uncertainty. For large businesses with HR departments and access to employment lawyers, these changes may be manageable. But for a small business owner who is also the manager, the bookkeeper, the person on the shop floor, they can be overwhelming. COSBOA has done its own research in relation to this. The 2025 Small Business Peak Benchmark Research Report was commissioned by COSBOA, where we surveyed over 1,000 Australian businesses, and we found that whilst awareness to workplace relations changes has risen to 48%, up from 44%, understanding, so awareness is one thing, understanding remains limited. Awareness of closing loopholes changes, which were arguably the most complex of all the reforms, sits at a low 23%. These are not numbers that suggest the system, in our view, is ready for further change. These are numbers that tell us that existing obligations are not yet understood and need time, further time for embedding. When small businesses don't fully understand their obligations, it is not because of bad faith. It is because the pace and complexity of reform has simply outstripped their capacity to keep up. Adding further NES obligations, no matter how noble at this point, before current ones are properly understood, will not improve employment standards for workers. In our view, it will lead to a reduction in compliance, and compliance is certainly something we all seek to achieve. The cumulative effect of these reforms is not simply iterative. The new obligation interacts with existing ones, creating a complex multiplier effect that small businesses are finding it difficult to absorb. Small businesses currently spend about 12 hours per week on regulatory matters, administrative matters, and 12 hours a week is beyond their capacity to absorb, and at the same time they're currently performing other tasks in running the business and making sure it's a profitable one, or as viable as it can be. Our view is that further NES changes risk dampening employment growth in the small business sector at a time when the national economy needs it most. Many of the reforms introduced in 2022 are still being bedded down. The right to disconnect is less than 2 years old and only came in for small business last year. the implications of the recent federal court decisions on annualised salary arrangements, although not a government decision, it was a court decision. Those things are still reverberating through the employer community. On top of payday super and the other things that have been mentioned by previous witnesses, our view is to proceed with further NES reform before these changes are consolidated would be premature. So in our view, we would call upon the committee as part of its process to recommend a regulatory pause on workplace relations reform affecting small business insofar as the scope of this committee is concerned, and resist adding further issues or items attached to the NES. In closing, what small businesses cannot sustain is a pace of change that outstrips their capacity to understand, resource and comply. This review is an important opportunity. We accept that, not to add further obligations, but to pause, consolidate and ensure that the standards already in place are working as intended. Thank you very much, Chair. Happy to answer any questions.
Well, thank you very much. Really appreciate both your submission and the evidence, also the statement you've just made. In terms of the changes that have been made, how do small businesses tend to find out about those changes?
So there's a number of ways. As has already been mentioned, they would have trusted advisors through their accountants, etc., etc. One of the things that COSBOA does is have a small business peak program that I referred to. That is funded by the Department of Workplace Relations through the PET program. It's an excellent program. It's currently receiving, I've just looked at the data last month, 95,000 new hits on the website from new users and averages approximately 100,000 users accessing information on that website. So the primary goals of that particular program are to educate small business on the changes that have occurred since 2022. And that's one thing to have a website. There's other things to go out to small businesses where they are and do the education piece. Yeah. So we have conducted roadshows purely on workplace relations changes to ensure that small business understands their obligations. Brisbane, Fremantle, Hobart. We're conducting one later this month in Albany in Western Australia. And we're focusing this year on regional centres, Ballarat, Wagga, etc. So to your question around how do we go about informing small businesses of their obligations, that's one way that we do it. It's a terrific way. We're quite proud of the peak program that we've done. And there are other ways that we're currently looking at improving the ability for small business to have access to information. And as was alluded by the previous witness, complexity in the industrial relations system exists. It is a complex system. There was also a reference to AI. AI can be good, AI can be difficult. But AI is an opportunity that we see that we can educate small business, provided it is checked on its accuracy. And that is an opportunity, particularly in respect to navigating the modern award system. Okay. A lot of small businesses resist going and having enterprise agreement negotiations. They rely on modern awards. But not modern awards, there's over 120 of them. Most of them are in excess of 200 pages. And they are incredibly complex. So what we want to do is essentially use AI as an opportunity to improve access to that. So if there's any particular questions that they have on AI, on the award, AI would be able to interpret the award to give them the correct answer.
Obviously the AI needs to be trustworthy though.
Absolutely, yes.
Yes. Where do you see the areas of, I guess, risk of non-compliance, if not non-compliance itself, occurring?
So if I look at the types of things that small businesses are accessing on the website, top three at the moment, and it goes in waves depending on what's happening in the media and the announcements by the government, but certainly payday super is top of the list. Right to disconnect comes in second. And then third is casual employment, which has been a constant. Casual employment and navigating the pathways to converting employees seems to be a constant. And certainly when I speak at forums, that's an underlying question that I get as to how I navigate conversion requests.
So it sounds like I mean, those are three relatively recent changes to IR frameworks. So that sounds like your members are pretty proactive in trying to seek information around those changes. You sort of said casual conversion has been an issue that, or casual employment has been an issue that has been raised quite a bit. What tends to be the issue there around casual conversion? Is it like wanting to understand, when someone's eligible for that, how to navigate it, or casual employment in general?
Yes. I think, it used to be in the Act that a casual was a casual if it was determined in your contract of employment.
Yeah.
Now, obviously, things have changed. And as a result of that, that's created some confusion among small businesses and some reticence to act on casual conversion requests without the need for expert advice, which takes up extra time, extra cost in some cases. There's mixed feedback. Some small businesses take the view that they need to really understand the steps in the process to ensure they're doing it correctly. Mm-hmm. In fact, most of them would do that. The issue, I think, is the time taken to really understand what's right and what's not, because there's just a general confusion about what's appropriate here. Other small businesses are taking the view that simply from an operational point of view it can't be provided, a conversion arrangement, and they're reticent to make those changes because obviously the employee's got some different advice and they might give rise to a dispute in the workplace, which is something we want to avoid. So our role in educating through the PEAK program is to make sure that they understand the fundamentals as to what's required. So how long does an employee need to be employed within your small business? What's the steps that you need to understand in order for it to trigger for a conversion arrangement? And if it works for your business and you can accommodate the employee's request and it meets all the requirements, then we would argue that it ought to be approved. But it's about making sure that you understand that complexity. So I deal with this on a day-to-day basis. For a small business, it's new and it can be intimidating.
Thank you for that. And something we've heard as well is intimidating for businesses to grapple with too are different kinds of leave arrangements. I'm not sure if many small businesses operate across different state territory boundaries, but eager to hear from you about your experiences with that, because long service leave has been brought up as an issue that people are grappling with, as has been paid parental leave, and understanding how that might apply, particularly with that return to work provision. So just really inviting your reflections on leave in those regards. Yeah.
The feedback that I get in the questions when I go to events around parental leave in particular, I have to say, every single small business wants to do the right thing. It's about navigating particularly the payment of the parental leave and who's responsible for that. And making sure that they've got that information so they can inform the employee, because the employee's got obligations in that process as well. So I think some employees think, I'm going on paternity leave, this is all up to you to organise. In actual fact, that's quite not the case. So making sure that they're aware and understanding, but my impression is, in answer to your question, they really want to comply and do the right thing, but that whole process in terms of approval, who pays, etc., through Services Australia, that does require some simplicity to make it easier. Yeah.
Thank you. And I guess long service leave doesn't come up too much in terms of the differences between states and territories.
It's not a major issue.
No.
I know here in Canberra they are talking about portable long service leave. So here in Canberra it's becoming an issue, but it's not a major issue that's been raised from members with respect to us.
Thanks, Chair. Thank you for making time this morning. Just wanted to ask a question a little bit around, I guess, making sure that there's some time in implementation of legislative reform.
Yes.
Generally speaking, from my experience from working in a union and also in an employer association, is there's generally a bit of a transition period, particularly for small businesses versus, big business. Can you tell us a little bit what you would be suggesting, given that you've indicated in your submissions that, how much time, basically, I'm asking, if it's not sufficient at this point, given how the various things that you've sort of touched on, on reforms, what would you be recommending from your experience?
Because BOA's view is that there be a pause on workplace relations regulatory reform, particularly in relation to small business, and that there be a period of time for them to catch up and absorb what's already been put into play. Coupled with that, some further resources and support in educating small businesses for them to take time out to understand what their obligations are. And then the third one would be a real understanding as to the impact on small business, because a one-size-fits-all approach, as has been the case with the passage of some legislation, has had a dramatic impact on small business far beyond those larger employers who have a far bigger capacity to absorb it and educate their people within their business around the new arrangements. So that's our view. We think after 38 major amendments, and we know that there's some more to come. And I'm not arguing whether or not the rights or the merits of those changes, that's not the point. The point is there's been a lot of change. And while it might assist someone like myself in my role, it doesn't assist small business trying to navigate these changes because they simply don't understand. And if I can reflect on that research that we did, where on closing loopholes legislation, which was the most complex part of the legislation, a lot of which affected small business, 23% awareness. That's not even understanding, but 23% awareness is incredibly low. Now, as we're measuring this, and we do every year, I'd like to think as part of the work that Asbethio does, part of the work that we do, the level of awareness is increasing, but it's a slow increase. It only increased by 4 percentage basis points last year. It was over 1,000 participation size. So our view would be, yes, we accept that there has been a tremendous amount of reform that has occurred, but there's an opportunity now to, I think, pause and allow compliance to be the key thing, and compliance is all about information and education.
Okay. And just one more question, Chair. Just touching on the awards and complex understanding, and obviously you'd be aware of the processes in the Fair Work Commission to do regular reviews on that.
Yes.
Are you suggesting that that's not enough, or in a sense of, I mean, from my experience, going through that process, both from an employer and employee perspective, that is the intention of that review, is making sure that it's plain language, and this is not just only for employees but also employers.
Yes.
Are you suggesting that it's not enough in that sense?
I think the intent is correct. So the whole modern award process was to attempt to simplify as much as possible award arrangements. But I don't think it's gone far enough in the attempt to simplify. So if you look at a lot of awards, particularly in restaurant and catering, etc., the number of classifications, the number of different allowances, these are complex arrangements for small business owners to navigate. Now, they rely on experts to assist them, whether they be payroll providers or accountants. But I do believe, in answer to your question, that there's an opportunity to further have a focus on how can we make it simpler so that they can be easily understood, they're written in plain English, and you don't require an accountant, an industrial relations expert or a lawyer to interpret certain things for you. You can, small business owners, they're smart people, they invest their own capital, they should have a document in front of them that allows them to interpret it themselves. In a lot of cases they simply can't, maybe because they don't have the time, but I think largely because they are complex documents that are too difficult to interpret.
But when you say they don't have the time, I think just setting good culture in a business setup as well, I think it's pertinent that they do make the time, right, for the success of their business. So,
Yes.
No, that's good to know. All right, That's all. Thank you.
Thank you. And I just on that question of review, we've heard from a number of witnesses that, it would be helpful to have periodic reviews of the National Employment Standards. Just inviting your reflections on that.
We don't have an issue with the periodic review of the National Employment Standards. So our view is it's not fixed. Everything needs review. So all we're saying at the moment is not yet.
Yep.
So our view would be, let's just take stock with what we've got at the moment. Let's try and focus on education, compliance, to get things where we all want them to be, and before we start introducing other things on the NES. That would be our view.
Well, thank you. And something that has come up a little bit so far too has been, obviously, the nature of businesses in Australia means we've got people running businesses from lots of different backgrounds, including different multicultural backgrounds, who speak different languages, or have a preference for a language other than English to understand particularly like legal matters. So just wondering what kind of outreach or gaps do you see in terms of communicating with CALD communities?
Yes, so that's a great question. And in the peak website that we've done, we made it very clear that we wanted the ability for it to be translated in major languages. So we invested quite a bit in making sure that that was the case, and had it tested that it was translating accurately, because in some cases it doesn't. So we have done that. So that was a recent innovation in the last 6 to 12 months, but I think there's more work to do. When people come to the roadshows that we perform, some of them are from an English-speaking background. I think there's an opportunity for COSBOA to have people that are available who can potentially speak main languages at that site. We'd be more than happy to do that. I think that's very important. Yeah.
No, thank you very much. I'll just check. Ms. Roberts, did you have any questions? Potentially not. Did you have any further questions? No. No, thank you very much. We really appreciate your evidence today and the submission. You'll be sent a copy of the transcript to request any required corrections. Right. Thank you.
Thank you.
Thank you.
Appreciate your time.
Thank you.
Sorry, I have a question.
Oh, great. Thank you.
Should I have a question?
No question.
Oh, great.
And we'll just suspend the hearings until 10 a.m. record, would you please state your full name and the capacity in which you appear? Give it a moment. Okay.
Hi, Anthony Denham, capacity as a private citizen.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. Having dispensed of all those, technical bits and pieces, I now invite you to make a brief opening statement before we proceed to discussion.
Thank you. Good morning, Chair and members of the committee. Thank you for hearing me today. I'm here in support of submission number 6, which proposes a narrow amendment to the Fair Work Act 2009, the extension of compassionate leave to an employee, their current spouse or a member of their immediate family who has been medically diagnosed as infertile. The amendment is 2 days of compassionate leave, where at present none exist. The gap in the current law. Under sections 104 to 106 of the Fair Work Act, an employee may take 2 days of compassionate leave on the death of an immediate family member, on a life-threatening illness or injury, on the stillbirth of a child, and on miscarriage. Parliament has accepted that some moments in life require a recognition beyond ordinary leave. There is, however, no recognition for the moment an Australian is told they will never be able to have a biological child. Around 1 in 6 Australian couples experience infertility. For most, the journey resolves in time, but for some, it ends at a diagnosis confirming biological parenthood is not possible. For that moment, the law currently offers nothing. Why I am here. In 2022, after years of trying to have a child, my wife and I were told that I had azoospermia, a condition where semen contains no sperm. It affects around 1% of men, approximately 135,000 Australians. Many women face equally devastating diagnosis of their own. Australia does not collect a single national figure for medically diagnosed infertility resulting in clinical finality. But the population concerned, while small in any given workplace, is real across the country. In March 2023, I underwent invasive microtesia surgery to determine whether biological fatherhood was possible. The procedure has a success rate of roughly 40%. Mine fell on the wrong side of that number. In an instant, the future my wife and I had imagined for ourselves was gone. There was grief, there was shock, and then before long, there was work to do. There was no compassionate leave available. I used personal leave, which is leave designed for illness. My wife, who had walked every step of that journey with me, had no automatic entitlement to be there to support me, be present and grieve with me. Nor did our parents or siblings, who were also affected in their own ways. It didn't feel right, fair or just. I raise this not because my experience was unusually difficult, but because it is shared by many thousands of Australians each year. Infertility is rarely spoken about openly. Azoospermia, in particular, is not commonly discussed among men, and the silence has consequences for mental well-being. It is part of why I'm speaking publicly today. Why this is a reasonable amendment. Before I make that case, I should correct one matter in my written submission. I said that compassionate leave provisions had not been amended since 2009. That is not quite right. Stillbirth was added in 2020, and more directly relevant here, miscarriage was added in 2021 via the Sex Discrimination and Fair Work Respect at Work Amendment Act. That 2021 amendment is the closest precedent for this proposal. Parliament accepted that miscarriage was a form of reproductive grief the compassionate leave framework had failed to recognise. I'm asking the committee to apply the same reasoning here. At the heart of this proposal is a question of consistency. Compassionate leave is available to those who can fall pregnant, but who then experience miscarriage or stillbirth. It is not available to those who are biologically unable to conceive at all. Both are forms of reproductive loss. The law currently recognises one and not the other. The reform itself is modest. The trigger, a confirmed medical diagnosis, is a once-in-a-lifetime event. It does not create a new leave category, and it is engaged only at the point of clinical finality. Other recent amendments, Baby Priya's law in 2025, the expansion of paid and domestic violence leave in 2022, followed the same logic. Some employers already provide this leave voluntarily. Mine did after I shared my experience. The NES exists to remove that lottery. to ensure that compassion at this moment does not depend on the employer an Australian happens to work for. In closing, last year, my wife and I were fortunate enough to welcome our daughter through donor conception. We are profoundly grateful, but our outcome does not diminish the gap in the law for those who will receive this diagnosis tomorrow. Ben Chifley spoke of the light on the hill, the steady, patient improvement of the lives of ordinary people. 2 days of compassionate leave on a clinically defined trigger will mean that the worst day of their lives, the law of this country sees them. I respectfully ask the committee to recommend that medically diagnosed infertility be recognised under compassionate leave provisions of the Fair Work Act 2009. Thank you. I'm happy to take any questions.
Well, thank you. Thank you so much for your written evidence, and thank you so much for appearing today and sharing your experiences, and congratulations to you and your wife on your little one. We've heard from, we've had a number of submissions so far to the inquiry around a separate category of leave for reproductive health issues. Do you have a particular view on whether, if that category were to be included in the NES, that would be the place to have the kind of leave that you talk about?
Thanks for the question, and through you, Chair. It's a very good question. I've thought about this a lot in the time since my diagnosis. So I think they're two distinct and separate issues. I think if you look at what the intent of compassionate leave is for, it's to deal with moments of grief that people go through, and it's unplanned. Death, you don't plan for death or serious injury or illness and those types of things. You need time to grieve and to deal with it as a human being. Obviously, I think it's 1 in 6 Australians have fertility, issues and struggles, as I mentioned in my submission. We had to do that separately at our own. My wife had to go through her own surgeries so we could do the donor conception. I think they should be dealt with separately. I think it would be good to investigate the merits of what leave provisions could be accommodated for people dealing with fertility issues, but I think they are two distinct and separate issues.
No, thank you for that. And I know too, in this conversation, there's obviously leave for, compassionate leave for the person with a diagnosis, and then also for their family members who may also be impacted and undertaking caring responsibilities. So I guess in terms of how that compassionate leave or carers leave would be quarantined, I mean, this is obviously how many, what would you think that would look like for both the person with a diagnosis and someone who might be affected or a carer for that person?
Thanks for the question, and through you, Chair. So I think it goes back to the fundamentals of the compassionate leave provisions. Yeah. It does allow for, the person directly impacted, their partner and their immediate family to access compassionate leave. I can only speak from my own experience, and obviously not having access to compassionate leave for my particular situation following my diagnosis as a result of my surgery. All I wanted was, my family and my partner to be there and, without question, to be there to support me, because it's not just me going through, I guess, the grief and the trauma. It's my wife and it's them as well. It has direct implications on them, and it's hard unless you experience it directly. I'd never even contemplated this before my own diagnosis and what impacts it would have. So I think it's really important that it is also offered and extended and included to partners and immediate family, because they are this support network. And at the end of the day, we are human beings, and when we deal with grief, we have to deal with it as a collective unit. It's extremely hard dealing with it individually.
And I guess having that category of leave, I mean, these are sometimes, I think people would potentially find these very difficult conversations to have with an employer. So having that extra category, would that make it easier then to be able to I guess, feel empowered in a workplace to take that kind of leave?
Yeah, absolutely. I think I think there's no shame in admitting that you have personal issues and struggles, and I was quite open with my workplace in the struggles on my journey, I guess. So I think in terms of accessing the compassionate leave, it wouldn't be anything different than what the framework already contemplates, which is you need to provide medical evidence that would satisfy a reasonable person. So, it's really up to the individual to how they navigate that with their workplace. But I think it definitely would empower them to speak up on it because, like I said, particularly men, they don't talk about these things. And the first time I ever heard about this condition was when I was diagnosed. And if that is, it's a 1 in 100 condition, I know hundreds and hundreds of men, and it's not right that I've only learnt about it or know about it, at the time of my diagnosis, and that means there's a general silence and therefore shame across men in not talking about it. So it is definitely linked to I guess, mental well-being and talking about those things, because if you internalise these things, it's not healthy.
Thank you. I might see if my colleague here has a question.
No, I don't have any questions, Chair, but I just wanted to say thank you, Anthony, for being vulnerable and making the time to contribute and share your experience on this inquiry. Thank you.
Yeah, and I think we're all very grateful for your contribution, and I'll see if Ms Roberts, who's on the phone, has any questions.
No questions, thank you, Chair. Well, knowing to IBF too, that most of my health outcomes sometimes, yes.
Thank you.
Excuse me, I got no voice.
Thank you, Ms Roberts. I'll just ask another question, if I may, then. Given that, the path of grief is never necessarily a linear and, predictable one, and something we've heard in other evidence around when people are experiencing chronic health issues, for instance, is documentation can become onerous to try and access leave. You mentioned earlier reasonable evidence, as a requirement, as a medical certificate. I mean, once a diagnosis has been made and there are, I guess, if there were kind of leave access issues there, would you think that just that one-off certificate should really be sufficient, or, to make it easier when, you're dealing with something that may be a little bit unpredictable, like grief or a chronic health condition?
Yeah, thanks, and through you, Chair. I think, yes, absolutely. I mean, I can only speak to my own situation, and I don't think it's necessarily something that would be, if the concern is that this might be something that could be abused in the future, I don't think that's the case. So with my journey, my journey took the better part of 1 year. To get to a fertility specialist, or to be referred to a fertility specialist, you have to basically get a referral from a GP and demonstrate you've been trying actively for a year. And then from there, it was another year before I had my diagnosis. So it's quite a lengthy and extremely costly process to go through. So to have I think there's a fair bit of weight to be applied to a determination, in my case, following surgery, which is the clinical finality from a fertility specialist saying that is the end of their journey. But yeah, you're right. Grief can come in many forms and in many guises. So I think a lot of trust should be placed in the medical practitioners that serve us. And if they make a determination that someone's dealing with a particular type of grief, then that should be taken.
Yeah. No, thank you for that. And, in terms of, and again, I respect you, speaking from your own experience here, what sort of amount of leave, in terms of days, would you think is reasonable to, deal with situations like the one you've dealt with?
Thanks for the question, and through you, Chair. So it's a very good question. So I'm coming from a base where there's currently 0 days provided for. So anything is better than zero. And compassionate leave gives access to 2 days. I guess from my experience, it is difficult. Because I had surgery, it was quite invasive surgery. I was under quite heavy painkillers for about a week. But I could probably say, hand on my heart, 2 days is probably not sufficient. But in the context that there's currently 0 days provided, 2 days is better than none. I think 5 days would be more aligned with that, because it is a long process to grieve, and there's a lot of emotions that go through your mind about what your journey might have looked like, how your parents might feel about other alternatives going forward, extending your bloodline of your family, and there's thousands of things that go through your mind following that kind of diagnosis. So because it's not a life that you had imagined. So, I mean, like I said, 2 days is better than none. But if there was an opportunity to consider further days, I think that should be maybe the Fair Work Commission could look at that, and maybe do some studies around grief to consider what's appropriate.
Excellent. Well, thank you very much for that. Just double checking there's no further questions. Okay. Well, thank you so much for your attendance here today. Thank you for your submission. As we've mentioned, we're all really grateful for your courage and speaking on your personal experience in this inquiry. You will be sent a copy of the transcript to request any required corrections too. Thank you so much, Anthony.
Thanks for having me. Have a good day.
Thanks, you too. Have a lovely day. And I advise that the committee will now take a break and the hearing will resume at 10:45. Good morning, everybody. I note that some sensitive matters may arise during today's hearing. The committee is mindful of the potential impact on individuals and communities and appreciates witnesses engaging with these issues. For those in person or listening online, if anything you hear today upsets you or causes distress, please reach out to Lifeline, 13 Yarn, Kids Helpline or other support services. There is also the Parliamentary Workplace Support Service and the Employer Assistance Program for Broadcasting, Hansard and the Committee Secretariat and for the committee itself. I now welcome witnesses from the Compassionate Friends Australia to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Hello, my name is Peter Hobson and I'm representing TCF Australia and TCF Queensland.
Hello, my name is David Murray. I'm representing TCF Australia and TCF.
Hi, my name's Vicky Shaw. I'm representing TCF South Australia.
Good morning. I'm Christy Roberts and I'm representing Compassionate Friends Victoria.
I'm Joy Rappo and I'm representing Compassionate Friends New South Wales.
Thank you. I think we have another witness. Sorry.
Friends Victoria.
Sorry, do you mind repeating that? I don't think we captured all of that. Sorry.
Anne Smith. I'm representing Compassionate Friends Victoria as well.
Thank you very much, Anne. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. And please be aware that too, if you become upset or need a moment to collect yourself, the committee can suspend briefly to give you time before proceeding. Does anyone wish to give a brief opening statement before we proceed to discussion?
Yes, I'll do that. I've prepared something, thank you. Every parent's nightmare is to lose a child. This is a cliche. However, for many families, this nightmare tragically becomes a reality. Every year in Australia, around 2,500 children and young adults under 20 die, as well as another 8,500 adults aged from 25 to 50. This means around 20,000 parents every year will have outlived their sons or daughters. The impact of the death of a child, whether it's sudden or anticipated, is devastating. The loss is outside the natural order. Our children should outlive us, and we do not expect to confront a future without them. The physical and emotional impact of the death of a child at any age in a family is immense, with complex consequences that are long-lasting. The Compassionate Friends Australia is a federation of state-based Compassionate Friends associations across Australia, and we support over 10,000 bereaved parents and families after the death of a child. Our services are provided by volunteers who are themselves bereaved parents, and we know that peer support from lived experience plays a vital role in helping grieving families regain control over their shattered lives. We thank the committee for inviting us to appear today and provide evidence on what we believe is a significant and systemic gap in Australia's workplace protections, which we refer to as the child bereavement gap. Currently, we have legislation and policy that recognises the devastating impact of stillbirth and infant loss through important reforms such as baby preas law. However, parents whose school-aged or teenage or adult child dies are generally entitled to only 2 days of compassionate leave under the National Employment Standards. Our central proposition is simple. The trauma of losing a child does not diminish as the child grows older, and the workplace protections available to bereaved parents should not depend on the age of the child who has died. We present evidence in our submission that demonstrates 2 days of leave is entirely inadequate for parents dealing with the immediate aftermath of a child's death. In those first days, families are not only grieving, they're managing funeral arrangements, they may be going through legal and coronial processes, supporting surviving siblings, and trying to function while experiencing psychological and emotional shock. Our submission asks for reforms for those parents, including increasing the bereavement leave from 2 days to 10 days for the death of a child as part of the NES minimum employment entitlements. Also for the introduction of a paid parental bereavement leave scheme. And in addition, ensuring that bereaved parents have the right to reassignment of work duties to minimise distress on their return to employment. These reforms recognise child bereavement not only as a personal tragedy, but as an employment and workplace relations issue with broader economic costs from the lack of adequate support. And this includes increased workforce attrition, reduced productivity, and long-term disengagement from employment. The evidence for our reforms is drawn from the lived experience of our members, and it highlights the real-world consequences of the current provisions. Consistent patterns reported by our members include frustration at the complete inadequacy of the standard 2 days of compassionate leave, and in many cases we have parents who exhaust all of their leave caring for a terminally ill child prior to the child's death. We also talk about members who have resigned due to an inability to access temporary changes in duties on their return to work, and also parents who've been subject to performance management while they've been experiencing the cognitive impairment and trauma responses that come with acute grief. These are not isolated stories. The death of a child is not a short-term event resolved in days. It is a permanent and profound loss. Workplace policy must reflect that reality. Australia has shown leadership in recognising infant loss within workplace law, and we are advocating that those reforms extend these protections fairly and consistently to all bereaved parents. Thank you again for the opportunity to appear today, and we welcome the committee's questions.
Thank you very much, and I thank you for appearing today and for your submission. This is obviously a difficult topic of conversation, but a very important one. In considering the recommendations around an increase in leave, I'm curious to understand, obviously, grief is not linear for people. And as you described this, the loss has really profound and ongoing impacts on individuals. So should, in terms of sort of the practical elements of accessing a proposed compassionate leave program that was expanded, that would not necessarily have to be 10 days in one hit, basically. It could be over the course of 12 months. Just eager to hear.
Absolutely right. That's something that you're absolutely right about. A person's response to grief and is as individual their relationship to their children. So for some, it's a good thing to be able to go back to work, and that helps as a distraction. But for others, it may be that you need more time off immediately. But you're quite right that it comes up over a period of time. So having the flexibility to take that leave over 1-2 years would be fantastic. Absolutely right. I know there's similar things for the Fair Work provisions for the death of a stillborn or a young child, where you can. I know it's unpaid leave in that circumstance, but the fact that you can take that leave over an extended period of time recognises the long-lasting impact of that grief, and that it can crop up at numerous times during that period.
Thank you. And I think something that we've heard in this committee so far has been around documentation. And what would documentation look like? Obviously, when you're going through this kind of loss, paperwork can probably feel a little bit, intimidating, overwhelming, unnecessary. Just trying to understand what you would recommend in terms of having an employer and an employee have the conversation around accessing leave and what documentation might be required.
Sorry, I was wondering if one of the others was going to take that. But for me, that would be obviously the death certificate is the thing that you would normally see. It's interesting you talk about that. I had an experience with when our son died. We'd just booked our anniversary holiday, and we wanted to then cancel that holiday in order to have funds back to bring our son repatriated, because he unfortunately died overseas. And the thing they wanted to see was a death certificate. And that makes sense. It's a difficult thing for people to have to bring, but I mean, it is for me, the core documentation that would go to support that claim, if that's what you're asking, about what sort of information you'd need to claim this leave. Oh, sorry, was the question more about what sort of family unit?
Well, I suppose, over the course of what we've...
For parents or...
Yeah, so look, what we've heard in relation to other kinds of leave, particularly with chronic conditions, for instance, and other, kinds of compassionate leave recommendations has been around, if you're not taking more than a few days leave, you shouldn't have to re-prosecute the case and provide new information, provide paperwork for every instance where you wish to take leave. So I guess I'm just sort of seeking, on the record, what your recommendations would be around that paperwork. And I see we've got Anne Smith here as well.
Yeah, thank you very much. I'm just going to suggest all of us have been involved in it. Death certificates are a part of the journey we just have to deal with. It's not easy, but the reality is we do have it for all sorts of different reasons. I would have expected that if I was to present a copy of the death certificate to whatever, the CEO, the HR, however the place is constructed, that I would expect would then be on my file. And if we had then access to that 10 days leave over the year, then that should be easily recorded in most if they're very small, the people will know anyway. If it's a large organisation, it should be easily systematised, and I would expect that to be the case. I've certainly had experiences where I was required to provide death certificates in very odd circumstances, and it really just drives you crazy when that happens. So the feedback you've got is real and true, but I would think it's a pretty easy path to go if the systems are set up.
Thank you very much for that. And I'll just see if my colleagues got any questions. Yeah.
Just on documentation, I presume even just a stat deck, I think it's just a whole process. Is that something also would be recommended by you all?
I think for me personally, I'd prefer the stat deck. It took a long time for my son's interim death certificate come through.
Yeah.
So accessing and having to need that, for that very beginning, I wouldn't have had that information.
Correct. Yeah. Yeah.
Yeah, and you still need the ability to be able to access that leave, of course. I'm just wondering, just while we're on this topic, if there are any other contributions people wanted to make. Yes, David, see your hand up.
Just on that, when my child died, we got a death certificate. He died in hospital. We got a death certificate very quickly. But I know some people are caught up in all sorts of criminal inquests and, take a lot longer. So, providing a death certificate is, inverted commas, for us was easy because our around death. So that would be something, I think you said a stat deck is parent just writes down and says, look, this is what's happened to my family.
Yeah.
What do you mean by a stat deck?
Thank you. Yes, thanks, Joy.
I was just thinking of, in some circumstances, there are parents who would prefer not to disclose their child's cause of death. So a stat deck would actually protect their privacy.
Yep.
How our children die does not change the grief that we live with and the support that we need. Is often extra levels.
Yeah, thank you. That's an important point there. Thank you very much. I know that in your submission you've suggested a need for further research into supporting bereaved parents. Just wanting to draw out how additional research or improved data collection may support workers who've lost a child?
Okay, so I can talk to that. Just to give a quick background, TCF QSB Queensland. We've been working with the University of Queensland for several years now, and we tried to get a few projects going. Probably the most relevant one to this committee will be when there was a qualitative study just interviewing parents of how they were treated in the aftermath of the death of the child. So what you find is a very broad range of reaction, and how that impacted the outcome for the parents and how they carried on in the workplace or how they felt about the work. But we don't know what we don't know. So it's only a small study. It's difficult getting funding for these studies. That's been my, this committee, I'd say to you, if you're serious about this issue, probably going to have to, a little bit of money in terms of research-wise. We're always trying to help UQ get money for research grants. Very, very difficult for grief, and particularly in grief in around losing children. So what I almost suggest is we don't know what we don't know. Vis-a-vis, we're going to have to do more research for best practices. Some institutions will do it really, really well. I mean, I had a little experiment where I was in the Air Force as a reservist and a school teacher, and the Air Force were magnitude better the way they treated me than the school system. So, and that's why I did a little experiment. So there's scenarios like that where you don't know, we need to find out what best practice is, record it, and then start disseminating that to larger organisations. So it would be almost that you can almost create a sort of good standard of reaction to the death of a child or an employee that doesn't, run risk foul of the sort of psychosocial hazards in the workplace where, you make going back to work, it's going to be difficult, but you don't compound what's gone on in their life and make things worse for them. That's where the research needs to go. And it might be longitudinal studies. What I mean by that is long-term studies. But it's something we can do and improve iteratively, over time.
Well, thank you for that. And, obviously you've mentioned your experience there with particular workplaces. I'm curious to understand, what support was not there? Was there any way to get information around compassionate leave entitlements from in a I think sensitive way from various different bodies like the Fair Work Ombudsman, for instance, that people have experience with, or unions, etc.?
I could write you a small novel on all that. Unions weren't particularly good. Okay. I know there was there was leave within. I work with Education Queensland. I know there was leave allocated for certain things, which are brought to their attention that no one seemed interested in. You've got these very, very large HR departments, and when someone comes along with a dead child, it's not something that we see every day of the week. So it depends how good the HR person you speak to is, how good your line manager is, and how good their line manager is. In the Defence Force, I got sent to a welfare officer, and my line manager called me every month. Just simple things like that. No one spoke to me from Queensland once I went off work. So it's just things like that. You always, you were managed. And so it was just some best practice. That's all. I've actually said this. I actually had a meeting with the Minister of State at the time about it. And I mean, look, I just want it to be better for other people. I'm not here to sort of complain or whine. I just want it to be better for the next parent that comes along to know how awful it is. No one seems particularly interested in gathering data and information on what seems to work for people.
Thank you for sharing that. Did anyone else have an experience they'd like to offer? Joy, I saw your hand up there. Yeah.
We would love to have more funding for research. And I know this is anecdotal, but in my volunteering role, I would meet with more than 50, up to 70 newly bereaved parents in a year. I facilitate 2 support groups, and overwhelmingly, a lot of their distress outside of their grief is the return to work and the lack of support, or a lot of issues around being supported and having the capacity to really work in the environment that they've been working in. So I know that I think Vicky will talk more to that, but it's one of the main issues that comes up in our support groups.
Thank you, Vicky.
For working parents.
Yeah, thank you. And yeah, Vicky, did you want to add to that?
Yep, sorry. Yeah, so at the moment, the compassionate leave is only 2 days. And our proposal recognises that the death of a child, it's not a short administrative event, it's a catastrophic life event with profound impacts on functioning mental health and workforce participation. And without the support and the extra pressure to go back to work prematurely when someone's really not prepared to carry on with the duties or in a right place to mentally do that, there's an increased risk of resignation, disengagement in the workforce, long-term workforce exit. Structured leave and gradual return to work pathways will improve our likelihood of sustainable workplace participation and allow people to continue along their work careers without prematurely resigning from their workplace. We've had one case study in SA where a woman lost her child. She was given the normal 2 days compassionate leave and she just wasn't coping. So she was planning to resign in another 5 years, but in that situation, she felt that she had to resign straight away without the support from her workplace.
Thank you for providing that information. And I'll just see if my colleagues have any questions. Any further questions? And Ms. Roberts hasn't suggested she's got any questions. Look, thank you very much, everyone, for your evidence today and for your submission. And I think, we all want to acknowledge, the experiences that you've had and how grateful we are for you sharing those experiences with us so that we can consider improvements for people in similar situations. So thank you very much for your attendance today. And just let you know, you'll be sent a copy of the transcript to request any required corrections. And I hope you enjoy the rest of your day and your weekend. Thank you.
Yeah, thank you.
Thank you.
Thank you.
Excellent. All right, I now welcome the witness from Morris Blackburn to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Yes, I'm Jessica Rose Miss Campbell, and I am here on behalf of Morris Blackburn Lawyers.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you. Firstly, thank you for having me today, committee. I'm very honoured to be here. And I feel like I am in a bit of a unique position to give advice on this particular topic as an employment and industrial lawyer. I've worked very closely with the NES for many years now, and I also work closely with unions, so I get an insight into how whole industries are affected by the NES. In particular today, given the terms of reference, we've really narrowed down on the topics that we wanted to bring to you that are relevant. Now, the first theme that we wanted to point out is just whether or not the NES is currently fit for purpose today. So in 2026, is it achieving the goals that it initially set out to do? My answer on that is no, not anymore. There are two key issues. One is gig workers, which you're probably all alive to now. So the Productivity Commission report from 2015 said it was 17% of people not covered by the NES. We can certainly assume that number is significantly more 10 years later. So we do need some more data on that to get a better picture of just how many people aren't affected by the NES. The second is a generational thing. So the NES is really designed around a continuous employer. It is there to benefit someone who has one job over a long period of time. And we can see that most evidently with the long service leave. We know that millennials stop doing that, and we definitely know Gen Z are going to have even more jobs than us millennials. So in that way, it's written in a way to benefit an employee who is getting ready to retire, which is, something really to think about, and how we can kind of look at different solutions around that. Portable entitlements is a great idea with that, and would certainly recommend looking into it. The second is looking at how it benefits women. Now, I just want to give you a quick history snapshot on how I've landed on this theory that it doesn't benefit women in the same way it benefits men. So early as 1902, we have the marriage bar laws that are implemented in Australia. So that is when a woman marries, she resigns from her job. It was a public sector job, but private sector followed suit. So generally speaking, women were resigning from their jobs. And the goal of that was to have them raise children at home after they married. What came very soon after that decision was the Harvester judgment, which was a case that set the minimum wage for workers. And that explicitly said in the case law that a minimum wage was for a man supporting his spouse and 3 children. So what we have there is what's referred to in academia as the male breadwinner model. Now, I argue that the NES still supports the male breadwinner model. Even though we've had entitlements put in there, they are non-economic entitlements, and they're really non-operative in terms of actually giving rights to women that allow them to come to work in the same way that men do. So what can we do about this? One of the things that we have been working closely with unions on is reproductive leave. So everyone's probably aware of that now as a policy suggestion, and I actually was able to work very closely with the Queensland Government in drafting our laws up there, and they've been working really well. And I know you're hearing from some unions today, so that I'll let them speak to that more. But the reason reproductive leave is useful is because it is gender neutral, but it helps women significantly more, in the same way that we've seen domestic and family violence leave support women on a larger scale than it has supported men. So to step away from this male breadwinner model style that the NES is still upholding, it is an actual entitlement that puts money in the pockets of people who are currently not being supported by these national employment standards. The personal leave is not supporting them in the same way that they need to be. These aren't occasional illnesses. They're often ongoing chronic conditions, and they're things like pregnancy, which you wouldn't put an illness tag on, right? So it is the greatest. Pregnancy is actually a great example for you to think about how the NES benefits a man and woman differently. So you've got an expectant mother and an expectant father, same amount of personal leave days for that full 9 months. And we know that the physical battle that woman is going through while she's pregnant is incomparable to what her partner is experiencing at work, yet the NES gives them the same level of entitlement. So it's a very clear distinction of how it affects people differently. So the last thing I wanted to talk to you about today is the unreasonable hours clause. So that's something that as a lawyer I work with quite regularly, and it's really not been effective in helping people manage a 38-hour work week. So I did want to just bring that to your attention today as something to consider, because it's been around for 15 years, and as a lawyer we still don't have case law to guide our clients and say, well, this is what a reasonable request for overtime looks like. So we really need to look at changing that standard to help guide us more, so that we can actually set a standard in Australia of what a 38-hour work week should look like and what reasonable overtime should look like.
Great, thank you so much both for your submission and your evidence today. I've got a number of questions, as I'm sure my colleagues do as well. So we've got Ms Amber Haberhigh here and Ms Roberts on the phone, and we may be joined by another member or two shortly. To this issue of long service leave to start with, we have heard from a number of witnesses and in submissions around the difficulties of federation and the challenges that poses to both workers and employers in really empowering people to take long service leave. There are different schemes in different states and territories, as you'd be aware, and there are some historical, areas of, what we would, I guess, call zombie clauses around long service leave. What would a stronger long service leave system with portability look like in modern Australia, and how would we tidy up some of the laws that we have at the moment?
It's a great question. One of the areas where it's working well is in Queensland in construction. So they have a portable leave scheme for long service leave, and the way that it works is it's effectively an industry levy. So you could do that through awards, or you could do that through peak bodies, but it's essentially everyone is from that industry is paying into this kitty, and that is the levy. And therefore, when this, let's say with construction, when that carpenter goes from this job to the next job as a contractor, then they're not giving up their rights to long service leave, because they are continually working. And that's kind of the message that you want people to see when you take long service leave as an entitlement. It's that you've worked for long service. It's not single employer long service, it's long service. So from an industry perspective, it would be a useful way to do it is, by levying companies to then have them pay for it as a whole.
And given that I suppose that people move across states and territories in various industries, I think construction's a great example of that actually. Would it make sense to try and nationalise that, or at least harmonise between states and territories? And again, how would you propose to do that?
If you put that within the Fair Work Act, that would be a way to harmonise it, because at the moment, the way that the state laws work, very similar to if you're a state-based employee, then state laws apply to you. Sometimes federal legislation will. If it's all workers and this is industry-based, the Fair Work will always apply. So if the Fair Work Act actually has within it that long service leave is portable, then that's the law. So if you move from Queensland to Victoria and the Fair Work Act is where you're pointing to say that my long service leave is portable, then it doesn't matter that you've crossed jurisdictions. It's an industry-based thing.
Thank you for that. Another area of leave that we've heard from witnesses about in terms of it could be a bit tardier, and I think this goes to some of the points you raise in relation to the gendered nature of how industrial laws apply to workers unevenly. Paid parental leave and the return to work provisions. Just eager to know if you've got any reflections or thoughts about that.
Yes, I do. So in practice, the return to work guarantee does not work. I see it every day in my job. Women are simply rejected a part-term application to return to their job. So the way that the return to work guarantee operates now is that your job will be preserved, but only in the way that you left it. So I've been on parental leave for the last 18 months. I'm a very hard-working, busy associate lawyer at Morris Blackburn. There is simply no way I could return to that job in the capacity that I did before I left. I needed to go part-time, and it was at my employer's discretion to let me back in. So I'm lucky I have a good employer. A lot of people don't, and that's where the Fair Work Act is really failing to give workers that protection. They're giving the discretion to the employer to determine in what capacity they allow that woman to return back to work. So that's a real problem that is, it's not doing what it says it's doing. It's not a guarantee. So a way to remedy that would be to make it a right to receive as opposed to a right to request.
Right.
So at the moment we're giving women the right to make this request to return to their job, but we're giving the employer the right to reject it. So it's basically saying to them, this is an entitlement. You go back to your job if you need to work part-time. That's accepted. And then in terms of the parental leave, an issue I have with the parental leave is it requires people to work. Again, it's benefiting these long-term continuous employees, which we know that women are not. And the reason they're not is there's a multitude of things, but it can be their reproductive health. It can be the fact that they're already caregiving for family. But we know that they're more likely to be in part-time work. They're more likely to be casuals, so precarious employment. And yet our access to parental leave under the Fair Work Act says in order for them to get that protection, they have to be working with the same employer for 12 months. So already you're disqualifying the very people who that clause was designed to protect. So that can operate portably as well. There's no need for that to be tied to a single employer. It is not a paid entitlement. It is simply the right to have your job held while you go away and have a child. And it doesn't run in tandem with our social services, which provides the actual paid parental leave. So that paid parental leave acknowledges that women are in precarious employment, and they don't tie your access to 26 weeks of paid leave to being with a continuous employer. They tie it to hours. They say you need to have worked 10 months, 330 hours. So I don't understand why the Fair Work Act can't mirror that. It's how we give women access to the 26 weeks of pay. Surely it can be how we preserve women's jobs for them when they return. And those two policies really should be speaking to each other.
Yeah, I think we've heard a little bit already about how it is really frustrating that there is this sort of gap between some of the policies there. I think potentially as a product of the fact that some of these arrangements came in after the NES was established. So I guess, we're here reviewing the NES after quite some period of time. Would you recommend more regular periodic reviews of the NES?
Yes, certainly would. Yes. And I think especially with the way that AI is coming in as fast as it is, it's certainly something, at least every 5 years I'd be looking at how much has changed, because I've been an employment lawyer for 6 years and I've had at least 6 new legislative changes that have completely changed the way in which we provide advice. So if it's hard for a lawyer to keep up, it's going to be hard for people to know how the Fair Work Act works in terms of their employment. So it would be great to do regular reviews.
Great, thank you.
Thanks, Chair. I just wanted to ask a question around how we can improve the NES for gig workers, and maybe just sort of expand a little bit on that.
Yeah, it's a great question.
Pandora's box.
Because it's very hard. It almost the architecture of the Fair Work Act as a whole doesn't support gig work.
Okay, yeah.
So it's a difficult thing. Parliament can take an accommodation approach, which is things like reproductive leave, things like parental leave. It's band-aiding, it's putting a fire out on a problem but keeping the fire going. Mm-hmm. So if you want to actually legislate for gig workers really in a way that is tangible, it requires redesign. So whether that's legislation or regulations that sit adjacent to the Fair Work Act that are quite different is one option, but that's a huge task for me to put to Parliament, so that's not my only proposal. The other way is just to put some more clarity around contractors and what it is to be an independent contractor, because at the moment, we have the recent case law on that, which I won't go into too much detail on, but it's confusing again for lawyers to make the assessment as to whether or not an independent contractor is covered by the Fair Work Act or not.
Yeah.
So some greater clarity around that would be excellent. But how to do it as a whole is a great question. I'll take on notice.
Thank you. No, Chair.
We've just been joined by Ms. Lawrence as well on the line. Now, I'll ask a question before I see, because I know she's just arrived, whether Ms. Lawrence has a question. Something we've heard from a number of witnesses, and I would appreciate your reflections here, is whether the Fair Work information statement is sufficient, and sort of drawing, I guess, on the difficulties of people understanding what maybe their contract arrangements are. It has been put to us that employment contracts is a model that could be recommended by this committee instead of a Fair Work information statement, or there may be some improvements to that information statement. So yes, really just inviting your reflections on how that might work.
Yeah, I'm not too familiar with it, to be completely frank, because I'm the information booklet and people come to me. So yeah, I couldn't give you a good answer on that, no.
Okay, well thank you, and I'll just see if Ms. Lawrence, do you have a question there?
Thank you. No, I'm sorry, I probably came in a bit late to be able to ask something that perhaps has not been fully covered or not. Thank you, though.
Thank you. What do you think the most urgent recommendation this committee could make would be to improve the NES?
The inclusion of reproductive leave. Yeah, I think that would have a immediate, tangible impact on the most amount of working Australians. This isn't a niche, discrete group of people who are lobbying for something that might assist, 50,000, 100,000. This is, at minimum, 48% of the workforce that is currently not being able to access the entitlements that they should be. It's gender neutral. It's going to benefit all workers, disproportionately women, in a positive setting, and it's a real proactive step away from this traditional breadwinner system.
I know we'll hear from witnesses later on today around reproductive leave too, but I know that you've had some experience working, as you mentioned, with the Queensland Government in this area. So just inviting your reflections on how that has gone.
Yeah, so some amazing responses from people that have used it, both men and women. We actually heard from a man that used it what they've done is they've given hours within that leave for screening. So it has made men proactive about getting prostate screenings that they weren't otherwise doing. So they've thought, hey, I've got this 4 hours leave for the year, might as well use it. And people have actually responded saying, they've found cancer. I wouldn't have had this screening if we didn't have this leave. I'm grateful for that. So that's how it can help men. But for women, especially for women with things like endometriosis and, women undergoing IVF and having pregnancy complications, it's 10 days personal leave is just simply not enough generally. And so not only is it making sure that they're not exhausting their annual leave, which is for a wholly different purpose, but it's validating their experiences. So in a similar way that some women have said that the domestic and family violence leave has helped them in having their employer acknowledge the trauma and the struggle by giving them that entitlement. You can't really put a price on that for someone who's going through something quite traumatic. So reproductive leave works in a similar way. It's that final acknowledgement of, we understand that your body is not cyclical in the way that a man's is. We understand that you menstruate, you gestate, you lactate. There's all these things that go on that are unique to you, and here's some time if you need it. They might not even use it generally, but that actual acknowledgement of it, I think, is really important, and it speaks to that male breadwinner model that we are still yet to step away from, in saying that I understand you're a female worker and you have different needs, and that's here if you need it. Makes the workplace a bit more approachable.
Thank you. And
Chair, can I just ask a follow-on there?
Oh, yeah, sure.
Sorry, just as a follow-on, did you have any sense on whether there's a particular sector that it would be limited to, or its size of business? Were there any exceptions that you would be thinking would need to be accommodated in the nest to allow for some workplaces where that would perhaps be more difficult to accommodate, either because they just don't have the revenue to be able to support backfilling and accommodating with people having to be out of the workplace at different times, ad hoc times and so forth?
Do you have an example of an industry that you're thinking of?
I think when we heard on one of our first early days of witnesses, there was some suggestions some sectors like the airline sector might be difficult, teaching may be difficult, like in the education system, but also the size of businesses, like some small business, obviously, where it would be difficult to accommodate for a workplace for an employer who might only have a small number of staff to then either cover that absence or try to backfill it when there's not that certainty of how much time might be needed. I think there was everybody was very sympathetic to the intention, but it's just the practicalities of being able for a business to be able to actually accommodate it in practice, or to be able to afford to be able to do it.
Yeah, so there's two parts to that. So on the affordability, it's my personal, I'll make this note, it's my personal recommendation. This is a state-funded leave. This isn't an employer-funded leave. I think it is inherently a social services issue. So therefore, it would be right for the government to come up with a structure that doesn't make this an employer-paid entitlement. Whether that's through taxation, it's for the committee to contemplate. So that's in terms of cost. So I wouldn't want to be putting that cost on small to medium or any enterprise. The second component in terms of staffing. So I empathise if people aren't, able to find the labour that they need. But I think the core issue from that is that you're asking someone who's otherwise incapacitated to work just to have a body in the room. I mean, at what cost is that? This isn't, they're not having a day off to go and get a massage. They're in pain, they're suffering, they're otherwise, very incapacitated and exhausting their annual leave. So I think when you look at it from that perspective, it's not something that we should be not thinking about implementing, because it possibly might be exploited by some and it may cause some labour shortages. I think if you take that approach, then we shouldn't have personal leave as an entitlement, because this is just an extension of that.
Thank you.
Thank you, that was really helpful.
Thank you. And I guess what we've heard with some witnesses so far too around providing reasonable evidence, and particularly for chronic health issues. And I think, reproductive leave would potentially cover some chronic health issues. What would be the reasonable evidence that is required or should be required for an employee to access that? We've heard different suggestions, such as anything, less than 3 days of sick leave, should not require a medical certificate or a statutory declaration, for instance. Yeah. And if there are chronic issues, then, a a single certificate should suffice for a period of time. Just, inviting your thoughts there.
Yeah, so I agree with the personal leave approach. So we don't ask generally for people to give a medical certificate straight away, and the Fair Work Act certainly doesn't. And I think with this, because of the nature of the conditions that you're dealing with, it's really I would say case by case, but you can set rules with it. So say, for example, if you've got someone suffering from endometriosis, they might need the days more often than someone who's going to get a prostate check. Where the sensitivity arises is around pregnancy and IVF. We would say for those circumstances, we wouldn't call that condition ongoing. So if it's an ongoing condition that's probably going to use the leave on a somewhat regular basis, then you might need to provide some medical evidence to explain what that ongoing condition is. And that's the Fair Work Act already asks that for any kind of prolonged absence. But it doesn't ask it of someone who is taking a day off ad hoc for an occasional illness. So if someone's going through IVF, they're not going to need leave for years at a time, and they're probably not going to need it on a cyclical basis. There might be a period of time in which they use it, and it's a sensitive topic. They might not want to share with their employer that they're undergoing that. So we would say in that case, you don't need to provide medical evidence or a doctor's certificate to say what you're going through. You can just, like with personal leave, you can get a certificate that says that you're undergoing a reproductive health condition, whatever the specific is. So I hope that answers the question. It's really, think of it as if it's an ongoing problem, medical evidence is generally required, like personal leave. If it's a short, occasional thing such as pregnancy, then, probably not. Just a basic certificate would be enough.
Great, thank you very much. Any further questions? Right, I'll just double check that Ms. Roberts or Ms. Lawrence don't have any further questions.
Thank you.
Great, okay, take that as no. Anyway, thank you very much for your attendance today. Thank you for your submission as well. And you will be sent a copy of the transcript to request any required corrections. Enjoy the rest of your Friday.
Thank you. Thank you very much for having me. Good luck.
Thank you.
Thank you.
Well, I now welcome witnesses from Families Australia to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Nadine Flood, Foster Care and Advocate, Families Australia.
Dr Lisa Griffiths, Board Chair of Families Australia.
Kelly Jebb, Foster Care and Advocate, Families Australia.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, Chair, Deputy Chair, members of the committee. Thank you for the opportunity for us to appear before you today. I'm Dr. Lisa Griffiths, the Chair of Families Australia, as well as the Chair of the National Foster Care Sustainability Group, and I'm also a Chief Executive Officer of AusChild. And across all those roles, I represent 600 organisations working to improve the wellbeing of Australian families, particularly our most vulnerable. I'm joined by Nadine Flood, who's a foster carer and former National Secretary of the Community and Public Sector Union, and Kelly Jebb, who's also a foster carer, and both will speak to their lived experience shortly. I want to draw to the committee's attention today some specific, concrete and entirely fixable flaws within the National Employment Standards, one that's quietly pushing women out of the workforce, stripping superannuation from our Aboriginal grandmothers, and threatening the stability of a child protection system in every state and territory. As of June 2024, there were 44,900 children living in out-of-home care across Australia, removed by the state because they couldn't remain safely at home, and almost half of these are Aboriginal and Torres Strait Islander children, who are 9.6 times more likely to be removed than non-Indigenous children, and the vast majority of these children live not in institutions but in family homes by 8,000 foster care households, along with 16,000 kinship care households, and we represent all of those carers here today. Now, these carers are overwhelmingly women, disproportionately over the age of 50. Most have household incomes under $60,000 a year. They sit squarely within the cohort that this inquiry is tasked with examining, and more than 80% have reduced or ended their employment to actually provide care. And foster care numbers in Australia have been declining for 15 years, and we really can't afford to lose any more. And without foster and kinship carers, the alternative for those children is what's known as residential care, and that costs an average of $830,000 per child per year. And it delivers measurably worse outcomes. So the way it works, a carer will get a call, often at night, within hours, not days' notice. A child's been removed, and they're asked by the state if they could take the child because they need a safe place to go, and they say yes. They say yes knowing that that child will arrive with profound trauma. They'll need to coordinate health assessments, specialist referrals, therapeutic appointments, all while holding down employment, and that's not protected. So we make 3 simple recommendations to this committee. First one is to amend the NES Community Service Leave entitlement to explicitly recognise statutory kinship and foster carers as a defined group, because child removal is not voluntary, it's not planned or predictable, it's unplanned, time critical, and is an emergency civic duty. So states and territories can't discharge it without having carers like this, and it belongs in community services leave. Secondly, because the NES leave entitlements interact, we would request you amend all relevant entitlements, including parental, personal, carer and compassionate leave, to specifically name statutory foster and kinship carers as an entitled class. Because the anomaly here is really quite stark, because it goes to the coherence of the NES itself, because had the child not been removed from risk of harm, their birth parent would be entitled to parental leave, whilst the carer steps up when the state intervenes. And despite them providing full-time, day-to-day parenting, often for years, they don't get that entitlement, and Kelly will speak to that more personally. So fixing this will keep carers in the workforce, preserve their superannuation, reduce the financial penalty that's driving women and disproportionately First Nations women out of work and onto Centrelink, and it will help address that 15-year decline we're seeing. Lastly, we request you commission a national data collection on employment characteristics of our carers into their employment status, their hours, their income loss and exits, and their superannuation impact. And your terms of reference identify those data gaps as something specifically requiring action, and it's really significant in the social services sector. Patchy state-level surveys are really not sufficient, which is what we rely on now. So a national evidence base will allow the government to measure full workforce impact, target then proportional help, and build the ongoing case for reform, particularly for First Nations carers who are actually quite invisible in the data. So these 3 simple things will not solve every challenge for out-of-home care, but they will remove a structural Commonwealth barrier that costs carers their jobs, their superannuation and their health, and costs children stable placements to give them a better chance of a better future. So these children in care have already had a lot taken from them, and they do deserve a system that stands with them and behind them, and our carers deserve that support. So I'll now hand to my colleague Nadine, who'll speak to what this means, not in policy, abstractions and statistics, but in an actual family's life.
Thanks, Lisa, and thank you, Chair and members of the committee. People will have told you you can't reform foster care while making savings. Thank you for not listening. I've spent decades in the union movement. I know what it means when a system fails working people, when the rules don't keep up with the reality of people's lives. What I'm here to tell you today is that this is one of those moments, and I know it from both the inside and the outside, having looked after 23 foster children. Our foster daughter was given back to the system by 4 foster families at breaking point. In between, she had 8 emergency placements. Chloe was on track to join her siblings, who aged out of the system without a family or a home, without a single supportive adult to love and care for them and help them recover from trauma. The Commonwealth will be paying for their trauma through income support, the NDIS and health for decades. State governments will pay for their homelessness, health, policing and, of course, child protection as the cycle continues. Chloe's mum was a foster kid who the system let down. Instead, Chloe is doing a TAFE course, making friends and working hard on her recovery from complex trauma. To achieve that, we have spent $40,000 a year, mostly on medical bills. Yes, we can get a lot of that back later after jumping through hoops, but meanwhile the bills keep coming. Supporting Chloe meant finding the time off work and taking unpaid leave to find the right specialists and get her to the appointments she needed. It meant hundreds of hours helping Chloe manage multiple health conditions and facing her fears that she is too much and we might be the 5th family to push her back into the system. To make this possible, I stopped paid work 2 years ago. I am one of the women who is invisible to the current NES provisions. I have joined the statistics of carers who had to leave their job to care for their child. We are lucky. My husband Scott has a job that can just pay our bills, but many foster carers simply cannot afford to keep caring. The South Australian Survey of Carers tells us 81% of carers have reduced or ended their employment. That is not individual choice, that is structural failure. Chloe's recovery is not an easy process. We have 4 specialists churning through 12 homes, means serious things get missed, misdiagnosed or go untreated. Scott and I feel deep guilt about the teenagers who've come to stay with us on emergency foster care, but we send them back to the system to go into residential care because we don't have the supports we need to take them into our family permanently. We've had to make the decision to only take more kids a few months a year until either we can fund fostering through accessing my previous superannuation or the system offers us more support. There's a 14-year-old girl I'll rename Lizzie who came to us in emergency care. She now lives on her own with a rotating roster of workers because there are no foster carers for her. 14. The New South Wales Government calls this intensive therapeutic care. I call it cruel. Without love, home, a functional family, there is every possibility she will end up with a dysfunctional life and a lifelong need for government support. Lizzie's intensive therapeutic care child package payment is costing upwards of $900,000 a year, depending on the provider's negotiations with the New South Wales Department of Communities and Justice. Lizzie desperately wants to join our family permanently. She rings our daughter to try and work out how Chloe got a family and a home and how she could do the same. She knows we've decided we can't take another child permanently until we can fund fostering through my super or the system offers support. Lizzie approached me nervously one night to put a proposal to me and Scott. Could she join our family if she committed not to need much from her mum, so I could go back to paid work, and if she committed not to have a lot of medical and psychological treatment, so we could afford it, but just to live quietly in our spare bedroom? It was one of the most awful conversations of my life. So state and federal governments are spending billions and failing. In Treasury terms, the foster care system is taking a time-limited child protection cost and turning it into a multi-system adult liability the Commonwealth carries for decades. In human terms, a foster care system in crisis is taking traumatised children and the people volunteering to love and care for them and breaking them. I'm going to leave the rest of my statement so that we can get Kelly's story.
Thank you. Thank you, Nadine. My name is Kelly Jebb. I'm also a foster carer. I work full-time and so does my husband. We've welcomed 7 children into our home, children who had nowhere else safe to go. About 4 years ago, a 10-day-old baby was placed in our care. My husband and I both met the work test. We'd each worked 10 of the previous 12 months, but because we were foster carers and not the child's legal parents, we were not eligible for the government's parental leave scheme. So we did the middle of the night feeds, we did 4 months sleep regression, and we showed up at work the next day, exhausted, sometimes accessing our own personal leave that we also share with our biological children and when we're sick, and with no formal protection. There was a point where we really seriously considered whether we could continue the placement. And if we had made that different decision, if we'd stopped, that baby would have faced yet another disruption in their first few months of life, at the very moment when secure attachment is most critical. We didn't make that decision, and that child just turned 4 years old and is thriving, loving kindy, excited to go to prep next year, but it shouldn't have been that close. Paid parental leave is not only about supporting physical recovery for birth parents, it's about giving children the best possible start to life. It's about building the secure attachments that research consistently identifies as fundamental to long-term well-being. If we genuinely care about that for all Australian children, and especially our most vulnerable children, then foster carers must be included. I often hear the comparison to jury duty raised in this context, and I think it's a fair one. Community service leave provides up to 10 days of paid leave that can't be refused by an employer when fulfilling a civic responsibility, like jury duty. I'm asking for the same recognition. But I want to add something. When a juror goes home at the end of the day, they leave the courtroom behind. I don't hang up my volunteer jacket when I walk in the front door. This is a full-time, 24-hour-a-day, 7-day-a-week responsibility. We need more carers, and we need to keep the ones we've got. With an ageing population and welcome increases in female workforce participation, we need more carers like me and Nadine, working carers. The simple changes we're asking for would help ensure job security and support for this vital community service. Thank you.
Thank you. I really appreciate you being here today and giving evidence, and I appreciate the submission too. In terms of, I guess, that additional leave, what would that look like in practice in terms of being able to access what you need when you need it as something either as part of the additional, as part of the sort of personal leave provisions with that recognition, or are we looking at something extra here?
We've looked at community service leave for the reason that there's actually a lot, it's probably the best parallels. Yep. So the NES community service provisions were built around activities that are defined, where the people in them are a defined class, jurors, emergency service volunteers. Foster carers have a lot of the same characteristics, so you wouldn't have to build a separate system. They have to be authorised and approved by the state in each government. So it's a clearly defined and very small cohort. So in that sense, it also shares the characteristics of it's unplanned. You can't tell when a bushfire is, you can't tell when a placement breaks down or when a child has to be removed. It's also for an undefined period about how long that carer would need just to get that child settled in. We've had children, for example, teenagers who've come to us straight out of a psychiatric unit in hospital after a suicide attempt. You have to be with them at least the first week they are with you. You have to put supports in place to make sure that you are protecting that child. So there is a similarity there, and similarly, it's a very small group of people. We're talking about 0.3% of the population who are foster carers, 0.2 are on jury duty, about 0.3 are defence reservists. So we think you could use that system. In terms of the other categories, it's not about changing the entitlements, it's about ensuring foster carers are included.
Yeah, no, that.
So it's just as a defined class. So we're just asking that fostering kinship carers be recognised because they're providing parenting duties. So they're not recognised like parents, so an employer can refuse. So Kelly could be refused to access parental leave, as she explained, even though she was performing parental duties. The state is the parent. You can't give the state parental leave, but you can give the carer the parental leave.
And reflecting too on, I guess, something that this inquiry wants to look at is the disproportionate ways that some people are not actually, I think, protected by some of these national employment standards. And we heard around sort of the gendered nature of some of assumptions around work just before. I know that you mentioned Aboriginal and Torres Strait Islander women are particularly impacted by, a failure, I guess, to recognise their kinship caring responsibilities. Just wondering if you could elaborate a little bit further on that and how that's affecting them in particular ways and what that means for the workforce.
Of course. So one thing to note, across Australia we have something called the Aboriginal Child Placement Principle, and that's enshrined in every state and territory legislation to provide protection so that Aboriginal children and young people, when they're removed from their families, they must first of all be cared for by an Aboriginal family member or kin, or an Aboriginal a member of the community, so that they can maintain that cultural connection and safety. So at law, the first thing that happens if an Aboriginal child is removed is that they will look to kin to provide a placement for them. Now, 63% of all Aboriginal children are fortunately cared for by Aboriginal carers. They're typically grandmothers, and they typically are on very, very low incomes to start with. And in fact, we included a case study within our submission to talk about an Aboriginal carer where she was asked to look after a 3-year-old kin, and she took on the first 3-year-old child. She maintained her employment, but then when she took on the second child, she had to cease employment because it was too difficult and the employer didn't make any provisions for her, and she had no entitlements. So it's without naming, unfortunately, that fostering kinship carers are a defined class. It makes it very difficult for any person, whether you're Aboriginal or non-Aboriginal, and you're a foster or kinship carer, to seek or demand protections from your employer to say that I need to access leave to take care of a child. And half the children that are in out-of-home care, as I mentioned, are Aboriginal and Torres Strait Islander children, so 20,000. So we're still talking very small numbers, but a very disproportionate sample.
Can I mention the Aboriginal Child Placement Principle, which is fantastic, also has an impact on the sort of emergency community service leave extension that we're talking about. We've looked after 4 Aboriginal or Torres Strait Islander children while the system was trying to find someone in their extended family who would agree to take them, who could go through a short, sharp, minimal assessment, not the full process that other carers go through. And that's actually a really important part of the system as well, because that's what supports that placement principle. Those kids have to be somewhere until you actually find that kinship carer.
And one of the other things it links to, in line with government priorities, is closing the gap targets. And the out-of-home care closing the gap target is absolutely going the wrong direction in terms of so the way it would work is ideally children are placed with Aboriginal and Torres Strait Islander peoples first. 63% are, but of course the corollary of that is that you've got another 37% that aren't placed there, and that in fact then worsens the gap in terms of closing the gap, because you want to ensure that Aboriginal children get back to family as quickly as possible. So by not providing the right employment conditions to retain Aboriginal women in particular in the workplace and make provisions for them, you're actually contributing to the closing the gap target worsening.
Thank you. See if my colleagues got any questions?
Yeah, I do.
Just one question. I'm just really interested around your experience that you shared, particularly how we can open it up to more people to provide that assistance. I just would like to get to understand a little bit more about your experience around that. And, you know, the anticipated requests that in the submissions, like how much more do you think that will open up for even people like myself or the sort of younger community that would be open to providing this kind of support?
Yeah, thank you. Yeah. I think, as I pointed out, you know, with an ageing population and an ageing caring population, it's really important to attract working carers. I think one of the concerns that people have is about being able to meet the child's needs while they're working full time. The paid parental leave is a particularly important one because infants obviously need that time and that bonding. I was very lucky to have been working from home and to be able to have, you know, basically just wear that baby for, you know, 12 hours a day. But it is really exhausting when you're working after doing night feeds. And I really wanted to make sure that he was able to stay stable. I think from a practical sense, the access to community service leave is also really important. We have a lot of demand on our time in terms of family contact visits, child safety home visits, other, you know, meeting medical support needs, etc. You know, I get 10 days personal leave that I use for if I'm sick, if my biological children are sick, and now I'm sharing that with multiple children in my home. It's a really simple extension to make sure that I can meet that child's needs without being concerned about employment security and, you know, just that entitlement rather than crossing your fingers and hoping that that will be okay with an employer. And I'm lucky to have a very understanding employer, but we know that's not the case across the country. Yeah. Thank you. I'll just check if Ms Roberts or Ms Lawrence have any questions on the phone.
Chair, can I just say a massive thank you to not just to your submission today, but for what you do for so many vulnerable people in Australia. Like, it's extraordinary the commitment and dedication that you are providing to bring security and comfort to children. And I'm just so thankful for what you do. And I think what you've shared is really, really insightful and constructive. And yeah, really appreciate your contributions.
Thank you, Ms Lawrence. I think
I concur with those comments too, Chair, but no questions to me.
Great. Yeah, well, we're all very appreciative of the work that you do and, you know, the submission that you have made. And, you know, thinking about this, you know, the data issue that you raise around collecting more information, obviously we, you know, to do that would inform probably the answer to the next question I'm about to ask. From what you know already though, like how often do you think caring responsibilities will lead to either workforce exit or people just not being able to take on caring responsibilities?
Well, as per our submission, you would see that what we've collected from different sources, and Nadine spoke about the South Australian survey. I mean, that was really quite poignant. The 81% of carers reduced their hours, and another 20% of those actually quit working. And we know from the data around the demographic shifts, and Kelly mentioned about the ageing. You know, the baby boomers. Used to be the carers that we would typically go to because they were single income households, and that's what sort of the NES was sort of predicated on in the first place. Now we've got dual income households and we've got millennials who we love, but they're not as available. So we would all want it, and when they are available, if they had access to community services leave, it would make it far easier for them to not feel guilty about leaving work to do emergency placements, which are critical, as Nadine spoke about, when you've got really crisis point with children. And we think that we will improve the recruitment rate of carers. Not a huge amount, but it would be substantially an improvement just to stop the decline. I mean, that's what we're really trying to do, is arrest the decline by providing just the recognition that carers do provide a parenting role across all of the NES provisions. I mean, ideally, of course, we could extend them to be broader than that and give some special compensation for foster and kinship carers. But right now, we just want them to be recognised like other parents. But to get to the data point, patchy state-level surveys are one way of doing it, but if you want really rich data so that you can really enhance the system for foster and kinship carers, that's why we would recommend commissioning a national data set.
Can I make a comment on that, just in terms of the labour market and the carer recruitment? We're with a very large not-for-profit in New South Wales, which has really tried to recruit millennial and Gen X carers, and also was one of the first agencies to target the LGBTIQ community as carers. My discussions with them, and we've been carers for 11 years, I've talked a lot, quite a lot of their younger applicants drop out during the assessment process as they start to realise the profound trauma these children and young people are carrying, the expectations of carers, and what they would actually need to be able to fit in with work and family. So they actually lose a lot of people before they become a carer because they're like, I can't make that work. And I think that's something where the NES could play a role to actually make that work better. Now, you know, I don't have the data on that, but I think there is substantial data, there's ABS, AFES, other data that says how many households can afford to be a single income household these days. You know, there's a mountain of data on those things. So it's fairly easy to see, well, there's not a lot of families in the position that we've been lucky enough to be in to say, well, we can live on a single income for a few years and actually make it work because we're older, we don't have a big mortgage, you know, all of those things. But if you're 35, you can't do that. So I do think some of that data is of value in this, even though it's you know, whole of cohort. And look, the baby boomers are dropping out. Several of the kids we've taken have actually been sent back to the system by their grandparents who are just too old and exhausted to cope.
No, thank you for that. Any further questions? And I'll just double check that Ms Roberts and Ms Lawrence don't have any final questions. I don't.
Thank you. Thank you.
Look, we really do value your attendance, your submission, and as Ms Lawrence indicated, the work that you do caring for people who really do need it. So thank you so much. You'll be sent a copy of the transcript to request any required corrections too. Thank you. And I advise now that the committee will take a break and the hearing will resume at 12:45. Ms Lawrence. I now welcome the witnesses for the panel for unions to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear? And I understand we're doing this in a couple of different tranches, so perhaps we'll go to our reproductive leave panel to begin with.
Sure. Kate Marshall, and I'm the National Senior Assistant Secretary at the Health Services Union.
Thank you very much. And I believe we've got Wendy Street and Rena Abbott-Jard at the FSU joining us virtually. If you wouldn't mind, please stating your full name and the capacity in which you appear. There you go.
What's going on?
Oh, sorry, I don't think we captured that for Hansard. If you wouldn't mind repeating that, please. I'm sorry, Wendy, if you wouldn't mind repeating. I think you're on mute. You're able to...
Apologies. Sorry.
Yep, that's right.
We couldn't hear you. We were just having some difficulty.
Okay, look, these things happen. Just for the Hansard record, just asking if witnesses would please state their full name and the capacity in which you are appearing.
Sure. Wendy Streets. I'm the National President of the Finance Sector Union of Australia, and I've got one of our members with me today, Rena Abbott-Jard.
Welcome to both of you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Thank you, and thank you for the opportunity to speak today on the operation and adequacy of the National Employment Standard. So I'm here, as I said before, on behalf of the Health Services Union, and I want to focus on one critical reform, which is the reproductive health leave into the NES. I just want to state that reproductive health is not a private inconvenience, it is a workplace issue, one that affects participation, productivity and equality. The evidence is overwhelming. Workers who experience reproductive health issues face absenteeism when symptoms are too severe to work, presenteeism when they push through pain at the expense of productivity, and long-term career modification when symptoms or treatment force them to decline shifts, decline promotions, or even entire career pathways. As one study cited in our submission shows, 90% of working women experience period pain and 40% are forced to either take days off or hide their symptoms. And this is just one example of the scale of the problem. Reproductive health issues are widespread. So 1 in 10 women have endometriosis, 1 in 6 couples experience fertility issues, 1 in 4 men over 40 undergo vasectomies, 1 in 7 men will experience a prostate issue, and each year up to 150,000 couples experience pregnancy loss. These are not fringe experiences. They are everyday realities for millions of Australians, unless someone is lucky enough to be covered by a progressive enterprise agreement, they must rely on personal leave, on annual leave to manage these issues, or worse, take unpaid leave. And these workers are being forced to choose between their health and their financial security. The human stories behind these statistics are powerful, and you'll hear one incredibly powerful story in a minute, but in our submissions, our member Lynn described how endometriosis and later IVF forced her to exhaust all her leave, her sick leave, annual leave, long service leave, and even all her entitlements to unpaid leave. She said plainly that reproductive health leave would have made things a lot easier and meant I didn't have to use up my leave allowances. Alex spoke of vomiting, nearly fainting in meetings and feeling too embarrassed to disclose her condition. She continued to work through debilitating symptoms until she felt she no longer had a choice. She told us that reproductive health leave would reduce stigma, protect her leave, and allow her to manage her health without sacrificing her career. These stories, unfortunately, are not rare, they're the norm. And the economic case is just as compelling. Research by the Bankwest Curtin Economic Centre found that reproductive health presently costs Australia $21.3 billion every year in lost productivity. Menopause alone accounts for $7.4 billion and menstrual pain $4.8 billion. Crucially, most of this cost comes from presenteeism, people working while unwell but unable to perform at their best. By contrast, a universal entitlement to paid reproductive health leave would cost just $1.7 billion annually after efficiency savings, less than 1/10 of the current productivity loss. This is an extraordinary value for a reform that would improve well-being, reduce turnover, and keep skilled workers in the workforce for longer. Reproductive health leave is also a gender equity measure. Women continue to face a gender pay gap of 11.5% and a gender superannuation gap of between 22 and 35% at retirement. Reproductive health issues are major contributors to that. One report found that menopause alone costs women $17 billion in lost earnings and superannuation every year. By reducing the need for unpaid leave, protecting career progression and supporting workers through treatment and recovery, reproductive health leave would help narrow those gaps and strengthen the long-term economic security of workers. Some state governments and employers have already taken action. Queensland and Victoria now provides for reproductive health leave for workers in the public sector. But relying on enterprise bargaining will leave thousands of workers behind. Only a national standard can ensure fairness and consistency. And the case is clear. Reproductive health leave would support workers in managing reproductive health conditions and treatment, reduce absenteeism, presenteeism and workforce turnover, improve productivity and mental health, strengthen gender equality and retirement outcomes, and cost a fraction of what employers currently lose through unproductive work. So this is a practical, evidence-based, economic, sound reform. It is also a compassionate one. So the HSU would urge the committee to recommend the inclusion of reproductive health leave into the NES. It is time to recognise that what reproductive health leave is, a fundamental workplace issue that deserves a national solution. So thank you.
Thank you so much. And I'm not sure if Wendy and Rena wanted to add anything to that.
Thank you, yes. Look, from the FSU perspective, our industry covers 540,000 workers. It's predominantly considered to be a gender balanced industry. We have been negotiating what we call menopause and menstruation leave since 2021. Our first agreement was with CBUS, one of the largest superannuation funds. They're now into the middle of their second agreement, and what we've been able to derive from their data is that the leave, and we've actually got two types of leave in CBUS. We've got the menopause and menstruation leave as well as reproductive leave, so they're classified in two different ways. But overall, with 700 employees, their costing it's costing them less than $1 an employee per year. So just to back up the HSU's figures, this is a much better financially for organisations, apart from the fact that, it recognises that women are different from men and they do need these different entitlements. But I might just hand over to Rena for her personal experience on this. Thanks, Rena.
Thank you. Thanks for your time, everyone. Imagine a bowling alley, child's birthday party, soaked clothing and blood trickling into my shoes. This is menopausal flooding. Cleaning myself up in the bathroom looked like a crime scene. I was in shock. And this was the first indicator that menopause at 43 was going to hit me like a freight train. Now, imagine I'm back at work. I'm proud to be surviving menopause and maintaining a career, but ashamed that I, like so many before me, hid it and failed in my leadership to promote awareness. Blood loss for me meant hourly dressings, clothing changes and showers, all stacked back to back, all stacked in between back-to-back meetings, facilitated by flexibility of working from home. But spare a thought for our workers on the front line, in call centres, branches, and under return to office mandates. Next generation workers have a right to live through menopause with dignity. My ultimate fear happened reading an email like it was an unknown language. Hormone changes and severe anemia had caused brain fog, and my superpower, my intellect, and the way I made a living was at risk. I can't prevent menopause, but I can minimise adverse effects by proactively managing my health. Reproductive leave is critical to symptom minimisation, and it must be separate to carers' leave that I use for family, injury, or an unwanted cold and flu. My next challenge was an invasive hysterectomy, and the recovery is 6 weeks. There was no reproductive leave. I was an executive in a new organisation, and I took 1 day off for surgery, rested on the weekend, and went straight back to work on Monday. I had no other accrued leave types and took a massive risk to my health. In hindsight, it was unwise, stupid even, and led to post-surgery wound infections, multiple antibiotics, additional GP visits, further damage to my heart, and additional strain on our medical system. Prevention is often cheaper than the cost of the cure. It is shameful in the finance sector and in the nation that many workers decide that the pressure to balance menopause and work is too great, forcing early workplace exit and a loss of earnings. There is also a significant loss of talent and intellect, zero knowledge and experience transfer, and a drop in productivity and loss to our GDP. Our campaign for reproductive leave in the NES is designed to support thousands of workers, reduce stigma, lift standards, and promote economic prosperity. Thanks, everyone.
Thank you. Thanks, everybody, for your evidence, and thank you, Rena, for sharing that with the committee today. We really appreciate it. You have experience of negotiating clauses around reproductive leave with employers. So I'd love to hear more from both the HSU and the FSU around what that process was like, and the arguments you've had to have, and where you arrived in all of that. Yeah, go first, and then we'll go to the FSU. Yeah.
So the reason why the Bank West research exists is because of the lack of willingness of people to negotiate. So we found, coming to the table asking for this, that the employers would say it would cost too much. What Wendy said is 100% what we've found in the health sector as well. When it's introduced, not a lot of people use it. In fact, it's underutilised. It's not overutilised. It's not abused. It's actually following the same path that family and domestic violence leave followed when it was introduced. A lot more people are able to use it, but don't. But it's there. It is there for those that wish to use it, which is incredibly important. So when they said that the cost would be too great, that's when we went off and we commissioned Curtin University to engage in this project and do the research. That research has actually been instrumental in our branches getting some more clauses across the line. However, the argument's still there. There's a generational argument of, well, we've never had it before, why do we need it now? There is an argument, again, that it will be abused, which we've seen absolutely no evidence of. So there is some willingness to now come to the party now we've got those figures, but there is still a stigma and unwillingness to even engage in the conversation. that's been my experience at the bargaining table.
Well, thank you for that. And FSU, Wendy and Rena, did you want to add anything there?
Yeah, thank you. Look, our experience has been the same. When I say we started negotiating for menopause and menstruation leave back in 2021, we've only successfully got that clause across 8 agreements all these years later, and that's, you know, to back up the HSUs, we currently have about 170 enterprise agreements, so we are constantly in bargaining. But the resistance of employers to actually take this on, including our major banks who can well and truly afford it. But so, you know, why I spoke about CBUS earlier was it's good now that we've got some second term agreements where we can actually use the hard data as we go back in and renegotiate again with the bosses to say, well, actually, your fear factor about the cost of this just doesn't pan out. It doesn't pan out anywhere. They've all got their averages of sick leave, right? Like, we all know that every worker's got a minimum 10 days of sick leave per year, and yet they've got their averages. Most workers take between 4 and 5 days of their 10 days every year. Very few workers use the entire entitlement year on year, and this leave falls into that same bracket. But it's an important one to have there, just like DV leave. So, you know, it is too slow a process to wait for every enterprise agreement, and there's still, you know, 200,000 finance workers that are award reliant. So NES is really important to make this an equitable. We can't simply just have these conditions where bosses agree and where there's sufficient staff to actually negotiate enterprise agreements. It's too slow a process, and it doesn't cover all workers.
I wanted to add too, I had, before my hysterectomy and change of organisation, prior to that, I had a really incredible manager who had a family history of endometriosis. So when she understood what I was going through with menopause and the flooding, she was incredibly accommodating, and we worked on a plan together to keep me in work and for it to be a minimal disruption, but for me to still stay in contact with the team and still be able to deliver on my role. I think that it would have been really helpful for her to have had the support from the organisation as well, because we were both making sure that we were doing things in a very diplomatic way while still wanting to raise awareness of it, but also making sure that we delivered and didn't skip a beat in our team. And so that was really important to me. I'd like to see some more support for managers and employers who are particularly attractive to women like us, who do want to do another 20 years in our careers, and don't want to exit too early for fear of not being accepted and for not being able to make the transition.
Thank you. And I think we've heard, and indeed the terms of reference of this inquiry really do go to how particular cohorts may or may not be supported through the NES. And we've heard evidence both today and previously around women's experience of the NES and the disproportionate impacts on their working lives, you know, in relation to having to take leave for care and other things. This potentially is one of those areas. So just inviting reflections there on how this may impact different cohorts and how this might actually help with workforce participation and people staying in the workforce for longer.
For me, for the HSU, where we've seen the greatest, I suppose, where women in particular have seen the greatest assistance are women in regional areas. So, you know, not enough is done globally around women's health. There aren't enough women's health centres. There aren't enough doctors and specialists that cater to women's health. And for those women who live regionally and then may need to take a day to travel to a major city, they need to then have their procedure or see their specialist or undergo fertility treatment and then take another day to come back. So they've got fuel costs, plane tickets, hotel costs, the costs of actually then seeing a specialist, and then the same on the return journey home. So they need the time and they can't afford to be without the pay. And these are people who are simply trying to look after their health and well-being. The reason why we've been inclusive at the HSU to not say that it is purely a women's health issue, because we also know men have a large part to play as well in the fertility side of things, whether it be that they need to have a prostate checked, whether they need to have a vasectomy, or whether they're actually supporting their partner while they're going through major invasive surgeries, like you've just heard from the FSU today, that women are able to have that support network there as well. So so women in regional areas is what we've been hearing a lot that benefit the most from this. However, women particularly going through IVF, we know IVF can be a very, very, very long journey. And to be able to have access to that leave, you don't get a choice of appointment. When you're going through IVF, you need to have an injection not only on a certain day but at a certain time on a certain day. There is no flexibility around that. So to be able to know that you can make that appointment and you can have a procedure to be able to give you the best chance to be able to start a family, I think that goes a long way to reducing the stress, which we know stress is a big contributor to infertility as well.
Well, thank you very much. And Wendy and Rena?
Thank you. Look, and we have definitely broadened our definition in line with the ACTU campaign, but we do still talk about menopause and menstruation leave at every bargaining table and every opportunity, because we think it's breaking down the taboo in the same way that the union movement went about domestic violence and making that okay to talk about and acceptable to talk about in the community. And, you know, the only way that we resolve these issues and change the nature of work and the nature of what's acceptable is to actually bring it out in the open. And forever, nobody has spoken about menopause and menstruation in the workplace in particular. So we do still like to use those terms because we are still breaking down. Our membership is 68% female, and this is a number one item because we've got some terrible statistics in our survey. We're losing 30% of women in the menopause bracket. Luckily, Rena was supported and didn't have to leave, one of the smartest ladies I've ever met. But we are losing way too many experienced women because they are embarrassed by the brain fog, embarrassed by not being able to keep up for what sometimes can be a short period of time, but other times can be longer. But it's important that we don't lose that level of expertise and those workers out of the workforce just because of a lack of understanding. So we do talk about breaking down those taboos. We think it's critical. But one of the other interesting points in our survey is what our members want more sometimes than actual leave is that flexibility to be able to work from home when they can and continue to work. It's not that they're not well enough to work with heavy flooding. It's that, you know, it's not practical for them to be able to shower and change clothes, whereas if they're at home, they can. So that's a very well utilised part of our clauses that we've negotiated, is that flexibility to actually work from home. Not all jobs can do that, we acknowledge that, but there's a huge percentage of jobs, certainly in our industry, where our members can work from home. So.
I think that's where the leave is critical. I was able to work through a lot of the symptoms that I had, making sure that my manager was aware so she could understand any decisions I needed to make in the day. But I do think about our frontline staff. other professions, even nurses, teachers, things like that. And it's critical that it's not just the rare few who have access to enterprise bargaining arrangements, but for those on in different working conditions get to have this coverage. I also think it's really important that reproductive health is something we look after as a human race. For men and women, and some of the most encouraging supporters of me when I start talking about this stuff has been the husbands and supporters of women going through menopause, but also they've had a bit of encouragement and inspiration to look after their own health as well.
Good, thank you so much. Let's see if my colleagues have any questions. Yeah,
thanks, Chair. Just particularly when we're thinking about men's health as well, do you have any data around employees, particularly male employees, actually accessing it for things like, and obviously be subject to privacy as well, but doing those checks that they need to do? Has this encouraged particularly men to be conscious of that?
So we've had some information from our New South Wales branch that prostate checks have increased. They have actually used the leave for prostate checks. And the good thing, they only need a day at most to have this done, maybe even only a couple of hours to be able to go do it. So yes, there has been an increase in men taking a more active role in their reproductive health, I suppose, and ensuring that their health and wellbeing is being looked after. So nationwide, I don't have any stats, but I know from our New South Wales, Queensland ACT branch that there has been an increase in men using it for prostate checks, and also there has been an increase in men in utilising it for vasectomies as well.
And just one other question.
FSU have any data there?
I don't have any hard data on that, no.
Next to.
And just from my understanding, are you able to sort of just walk through generally around like the standard of evidence and like notice, like what does that look like just for Hansard?
So what we have negotiated in agreements at the moment is that you need no more than if requested. So if it's not requested, you don't need to show it, but no more than what a doctor would require. So it would be something along the lines of Kate Marshall is suffering from a reproductive health condition. The condition doesn't even need to be named. And that is enough to trigger the reproductive health leave clause or the flexibility arrangements. So there's still needs to be, if required, that element of privacy about what the reproductive health condition is. Obviously, there is still some concern from women in particular if their employers find out they're trying to get pregnant. What does that mean? So there's still a protection there around that reproductive health condition, because it could be a range of things.
Great. And FSU, did you have anything to offer there?
Look, in the aid agreements where we've successfully negotiated, we don't have any requirement for medical certificates. So it doesn't become invasive. So it's just employers are trusting of their employees with just a phone call to say, I'm taking reproductive leave today. So no requirement for them to go to a doctor on a regular basis or even once a year to say, suffering from endometriosis or whatever. We negotiate that they don't require that.
Thank you. And I'll just check if Ms. Roberts or Ms. Lawrence have any questions online.
Thanks, Chair. If I could maybe just jump in first. I think it's really compelling, the evidence that you and others have been presenting today. And I'm just wondering whether I could just reflect on an earlier witness this morning, Mr. Anthony Denholm, who spoke to male infertility and the proposal perhaps to extend compassionate leave to infertility, and just wondered whether you had any views around that kind of categorisation as for people particularly needing to work through that grief, and how you might see it framed in the NES that catches I think you've already sort of spoken to it being gender neutral, but how do we best reflect the need for people to be able to have the time it takes to work through grief, be it around infertility or a loss of a child, as in the context of compassionate leave, as well as reproductive health?
Sure, thank you for that. So where we haven't been able to negotiate reproductive health leave into enterprise agreements, and we would include pregnancy loss, however a pregnancy is lost, within reproductive health leave and the flexibility. However, because pregnancy loss, and 150,000 couples every year experience some form of pregnancy loss in Australia, which is massive. Where we haven't been successful in putting it in, getting reproductive health leave into an enterprise agreement, we have negotiated pregnancy loss to form part of the compassionate leave clause. We haven't had any pushback with that from employers. I think it's very hard to push back where someone is going through something as traumatic as a pregnancy loss, no matter when that pregnancy loss occurs. It is deeply traumatic, and we haven't had any pushback with regards to that being in the compassionate leave. For us though, when we talk about reproductive health leave, we have got a clause in there that does include pregnancy loss as well, because obviously when you have pregnancy loss, there may be some further surgeries, doctor's visits, etc., that goes along with that. So it's not only just the actual physical and emotional trauma of losing a potential child, but it's also then all the medical follow-ups that you have to engage with as well.
Thank you very much. And FSU?
Thank you. Look, our agreements, certainly the ones where we've got the 8 reproductive clauses in them, we have been negotiating for decades around paid parental leave and those clauses, and we've had for a very long time in a huge percentage of our agreements gender neutral parental leave clauses, which include if you lose the baby anytime from 20 weeks on, you're entitled to the full parental leave allocation, and that because it's gender neutral language, that is for any parent to actually draw on. So that's where ours are covered off at this point in time.
Thank you very much. Ms. Lawrence, was there any further questions?
Yeah, and just interested also, appreciate about the loss of a child. I guess the witness earlier today was trying to go back one step further in terms around infertility loss and whether you could see a pathway for that being captured as well as compassionate leave. So maybe just a comment to that if you don't mind. But the second question I did have, though, Chair, is just what evidence you might have with respect to, and I don't want to exclusively say sandwich generation, but people who find themselves caring for elderly parents, maybe grandchildren. We heard earlier witnesses from Families Australia speaking about foster carers, and just the extent to which you might have evidence about the impact having within the workplace and the extent to which it can be accommodated within existing leave provisions under the NES, or whether there needs to be a review on that front as well.
So with regards to fertility loss, we've put that all within our reproductive health leave clause. So we haven't actually considered putting that in compassionate leave. It doesn't mean that we'd be quite happy to see it anywhere really, as long as people had access to it. But yes, going through. It's traumatic going through the trauma of trying to get pregnant, then going to a specialist and being told you can't. And without other certain interventions, that emotional toll can be quite debilitating, and can then move on to other mental health issues and concerns, which does not make one productive in the workplace. So absolutely, we think that fertility loss should be included. We have it included in our reproductive health leave clause, but do not oppose it being considered in compassionate leave. Should I stop there and let FSU answer that part of the question? Sorry.
Look, I think it's interesting. We don't have it anywhere at this point in time, but I think this is an area that is opening up to new clauses, and where do they fit, rightly or wrongly. I wouldn't like to see them fit necessarily in compassionate leave, because it's usually so restrictive to 2 or 3 days, which is just not sufficient. So, I think if we're broadening the definition, they would sit better in reproductive leave issues rather than compassionate. But I'm a bit like the HSU, doesn't really matter, not tied to any particular clause. It's about getting people the entitlement and the leave that they actually need. I'll leave it at that.
And sorry, what was the second part of the question?
The question was just about carers' leave for both foster caring and for caring for aged parents and other people. And
okay.
Grandkids.
Yeah, so there's sort of that sandwich generation, isn't there, where you're looking after aging parents, but also children as well. So not only are we seeing, and I say women because it is majority women who get the phone calls of their child is sick at school, you've got to come pick them up, or someone needs to be, an elderly parent needs to be looked after or picked up, or doctor's appointment. So yes, there is that sandwich generation that we're hearing is getting it from both ends. And with the rising cost of living, obviously they have to hold a job down as well. So they're fighting many different battles on many different levels, and unfortunately the thing that drops off is them and their own health. And we think that having something like this within the NES, as the FSU said before, it's there for people to utilise, but it's there to break down stigmas, and it's there for women to say, it's okay for me to look after myself and take time for myself to see these issues addressed. We know with things like endometriosis, we had one member say to us that she'd gone through, she'd been suffering severe endometriosis pain, bleeding, vomiting, every month for 21 years, never, ever, ever got it checked out because she didn't have the time. And then when she did actually get on the wait list, it was like a 7-year wait list to see a specialist. This is in Victoria. And then when she finally did get to see, got an appointment, she had to cancel that appointment because she had responsibilities towards her parents on that day. And of course, she put them before herself. She finally has been treated, but it took over 2.5 decades to be able to do so. So yes, we are seeing that a lot of people women are looking after others before themselves, and we think that this clause will go a long way to encouraging people to actually take the time. And we can see that by doing so, perhaps there'll be, cancers that are caught earlier that are able to be treated, that there are reproductive health conditions like endometriosis that you don't have to go through 20 years of pain and suffering until you can be treated for that pain and trauma.
Thank you. I'll just ask the FSU if they've got a response there.
Look, we broadened the definition for carers leave quite at least a decade ago, because this sandwich generation, as we call it, we've also got some clauses around for actual grandparent leave. So recognition of people working longer, but having that strain of, family responsibilities and into that next generation of needing to assist with childcare and so forth. So we've broadened those definitions quite a long time ago. And I think the gender neutral way of writing these clauses is showing good results as well. Like in NAB, which we saw some figures the other day. So 3 years ago now, we negotiated the gender neutral parental leave clause, and the uptake of men taking a full lot of parental leave has been through the roof. Like, it's gone from less than 100 to 1,500 in that time frame. So a massive increase that can be built on and should be built on, because this is part of the solving the problem of pay equity, which remains a massive problem in our industry. So the more that we can get men and community recognising that it's okay for men to actually take that break and take on these extra responsibilities, the more that it broadens that across the entire workforce, and it's not just the burden on our female workforce. So that's the way we've been dealing with it.
Well, thank you very much, and I'll thank this.
Sorry, Chair.
I think
if I could just ask,
I think we do need to.
If I could just get any more data on that, that would be fantastic, particularly around the take-up of compassionate carers leave. That would be great.
We'll put that on notice because we do need to move on now. Thank you. So we've got our next panel from the union. So I'll just ask you to introduce yourselves and the capacity through which you appear here in the inquiry for Hansard.
Thank you. My name's Anthony Hack and I'm appearing for the National Tertiary Education Union. I'm an industrial officer.
Thank you. I think we've got some people joining us online.
Michelle Purdy. I am the Federal Aboriginal and Torres Strait Islander Officer, Education Officer for the Australian Education Union.
Thank you.
Good morning, Chair. My name is Arundhati Kandel. I'm the Senior Industrial Officer at the CPSU.
Well, thank you very much, and I'll invite you to make an opening statement.
Thank you. I'll go first. Yep. And then just being mindful of time, I'll try and speak quickly so that others can speak. And I'm going to be mainly speaking about cultural leave today.
And we can go for 10 minutes longer, just to let you know.
Thanks.
So, no pressure.
I believe Arundhati's going to be speaking more to the definition of kinship, so I won't cover that now. So I'm Anthony Hack. I'm a Jardwan man from Watchabalik Nations, which is Western Victoria, and currently living up in northern New South Wales in the federal seat of Richmond. I'm an industrial officer with the NTU, and cultural leave, it's very important for our members and for myself, so I'll talk a bit about both. We've got members. The membership of our Aboriginal and Torres Strait Islander staff in the university sector is growing exponentially. It's growing at a much faster rate than non-Aboriginal and Torres Strait Islander staff in the sector. That's been happening for a number of years, and the rights of the Aboriginal and Torres Strait Islander people in the university sector has always been a large focus of the union for decades. We see it as core union business in the sector. Members have been fighting for these types of conditions for a long time, and we're very proud that we have achieved cultural leave in every single enterprise agreement across Australia, I believe. That hasn't always been easy. Like, there was a question before about how those negotiations go. It hasn't always been easy. Like, actually, at one of our universities last year, they took a day of industrial action, strike action for a full day, specifically about the Aboriginal and Torres Strait Islander clauses. So it hasn't always been easy, but generally there is an understanding that comes from management as well about, you know, Aboriginal and Torres Strait Islander peoples being the first peoples in this land, and that this type of leave is very important for us to uphold our cultural, just to keep our cultures strong. It is obviously our cultures are ongoing and alive and have been the whole time, and we've got cultural obligations that come with that. And for me, myself, personally, I do use cultural leave. I don't live on my country, and I live a fair way away, but I'm a member of my land council, the Barangi Gadjin Land Council, who has meetings several times a year for all members to be invited to come and discuss cultural business that needs to be determined by the mob. And it's crucial for me to be able to get down there and stay connected to community, stay connected to my country. It's really regenerating when I go and participate in community like this, and then I can come back refreshed to my work afterwards. And you know, it's great for our members and for myself that we've got these rights in the enterprise agreements, but really, like, it shouldn't be reliant on the strength of the union to negotiate these clauses. Like I said, it was at USID, our members took strike action to win some of these clauses, and that's not possible for a lot of people that don't have enterprise agreements, don't have a strong union, and it's crucial for this to be recognised in the national employment standards for a universal right across the board.
Okay, thank you very much. And do anyone else have any opening statements they'd like to make? Yes, please.
Thank you. I'd just like to, I'm a Chulaway Palawa woman from Ridgewood, Tasmania, now living and working in an Aboriginal role. I'd just like to say that the AU, the Australian Education Union, represents over 200,000 members in public education through preschool, school and the TAFE sectors, and in disability and early childhood as well. We have more than 3,000 Aboriginal and Torres Strait Islander members, and like my colleague there, it's our Aboriginal and Torres Strait Islander membership which is growing and has been growing for the last 5 years, greater than our other membership. We also have over 83% of Aboriginal and Torres Strait Islander students learning in public schools and taught by our AU members. I think I'll just move on to what we're talking about today. Cultural and ceremonial and kinship leave is of paramount importance to the wellbeing and retention of Aboriginal and Torres Strait Islander employees. It provides essential opportunities for individuals to participate in significant cultural and ceremonial activities, including business, community events, and the fulfilment of cultural responsibilities such as caring for country and kin. The provision of such leave not only demonstrates profound respect for employees' cultural obligations, but also cultivates a generally supportive and inclusive workplace environment. By acknowledging and accommodating these leave requests, organisations can foster enhanced employee satisfaction, improve retention rates, and build trust, ultimately benefiting the broader community. Specifically, paid, accessible cultural and ceremonial leave is essential because it, supports well-being, promotes retention, enhances trust and respects diversity, and encourages inclusion across the workforce. Ensuring that cultural and ceremonial leave remains successful and is administered efficiently is crucial for fostering a truly inclusive workplace that respects and values the diverse cultural heritage of all employees. I'll just mention that generally in education we have around 2% of the workforce which is identifies as Aboriginal and Torres Strait Islander, and yet closer to 3.8% of the student population is Aboriginal and Torres Strait Islander. And what we find is the recruitment of new staff is incredibly difficult, particularly with Aboriginal and Torres Strait Islander teachers and education support staff in regional and remote areas, and the retention of those staff who are working in public education is incredibly difficult because of the cultural load that is added to the work that our incredibly dedicated teachers and education support staff and their leadership take on. So one of the critical things around cultural ceremonial and kinship leave is that it helps balance out some of that cultural load that impacts our Aboriginal and Torres Strait Islander education workers. And while we have the cultural leave in most of our jurisdictions in our enterprise agreements, but not all, ceremonial leave is less so, but in some of those, and kinship leave not at all. So for us, it'd be relying on the national employment standards to balance out what some jurisdictions have and others do not. Thank you.
Thank you very much, Michelle. And Arundhati, I think you had a statement you were going to make as well.
Thank you, Chair. I will try and keep it brief. I understand we're running close to scheduled time, but thank you for the opportunity to appear before the committee today. We welcome this inquiry, both for ensuring that the NES provisions are operating as intended and also for meeting the contemporary needs of modern Australian workplaces. And I think the matters that we're discussing this afternoon about the introduction of reproductive leave, a broader definition of family to recognise kinship and ceremonial and cultural leave goes to that latter point about necessary changes to the NES to meet increasingly accepted community norms and expectations. We say that these changes progress inclusion and support employees, particularly in the context of cultural and ceremonial leave and the broader definition of family, to meet those obligations. So I just wanted to speak briefly on the broadening the definition of family to recognise traditional kinship. So access to NES leave entitlements for both caring and compassionate purposes is based on needs that arise in relation to an employee's immediate family. And under the Fair Work Act, so Section 12, which provides a dictionary definition, the current definition of immediate family is defined quite narrowly. It's limited to a spouse, a de facto partner, a child, parent or grandchild or sibling of the person or of the spouse of the person who applies for the leave. And we would propose a definition that recognises kinship relations. And as my colleagues have spoken of this morning, kinship is a really important feature of Aboriginal and Torres Strait Islander socialisation and family relationships and obligations. And they can be very complex, and they vary from community to community and from clan groups, is my understanding. And employees of called backgrounds, so of culturally and linguistically diverse backgrounds, also may have kinship relationships under their customs and traditions in the communities that they belong to. And so we believe that a broader definition would mean that employees with those kinship relationships under their customs and traditions would be able to then access carers, compassionate and bereavement leave that goes beyond the narrow definition of family. And it is a small change, but it is a meaningful change that really supports employees in their personal lives. On ceremonial leave and cultural leave, we know that Aboriginal and Torres Strait Islander people have obligations to kin and country that are not properly recognised or accounted for in the existing employment framework, and that those workers face the challenge of walking in two worlds, as it's been put to me before. On one hand, they need to meet their obligations to kin and country, which may require them from time to time to participate in or perform ceremonial duties. And on the other hand, they need to meet their workplace obligations. And those obligations in the workplace are structured on non-Indigenous policies and practices. So it's really hard for them to balance that. And workplaces need to be more responsive to the needs of Aboriginal and Torres Strait Islander workers so that they can participate in those duties and perform those rights and continue those important traditions and practices. And so we say that the NES should be revised to reflect that need. Similarly, the provision of paid cultural leave for workers to meet cultural and religious obligations and days of significance that are associated with their culture or their faith is important for fostering inclusive workplaces and supporting the needs of a diverse workforce, a diverse multicultural workforce. So in terms of the CPSU's experience, we have had some excellent outcomes in enterprise bargaining, particularly in the Australian Public Service, in service-wide bargaining, and we are proud of those outcomes. So all of the provisions we've just spoken of, the broader definition, cultural leave and ceremonial leave, we have secured those in bargaining in the APS. 104 enterprise agreements in the APS include those provisions, and that means that people can participate and fulfil those cultural and religious obligations and ceremonial duties, which are not otherwise explicitly recognised in the Anglo-Australian calendar or in our public holidays. The changes support changing community cultural norms and needs. And as I said, they progress inclusion and they progress racial equality and they promote workplace understanding, respect and trust as well. What I can say about our experience in the APS is the changes have not been problematic. They have not been a cause of industrial disputation at all. In fact, they have supported employees to better meet those requirements, and it's also contributed to the overall APS employee value proposition. So we would say that, like my colleagues have said, people shouldn't have to rely on bargaining and progressive agreements to access these rights. The provisions should form part of the National Employment Framework and minimum standards. Thank you, Chair.
Thank you very much. Thank you, everyone, for your opening statements. We've heard today from Families Australia talking about kinship care. And I'm really interested in sort of reflections there because they made the point that expanding definitions would actually help to contribute to improved outcomes under our Closing the Gap targets. So I really want to understand your views in terms of how changes to the NES actually might have those broader impacts too.
Definitely. There's actually something in my notes which I skipped over because I was conscious of time. But there's definitely, obviously, still inequality, like systemic inequality in Australia at the moment, and the Closing the Gap has been a long-standing initiative which hasn't been working as well as intended. And I think definitely providing a leave type for Aboriginal and Torres Strait Islander people to be able to go and be in culture, be on country, and is obviously, like I mentioned for myself, is really regenerating for my own well-being, and I can see that would be hugely beneficial across the board.
Great, thank you very much. And might go to Michelle and then Andati.
Thank you. Your question reminds me of one of our members that has an incredible capacity, even though they work full-time in a managerial position, managing an Aboriginal team, but has their own children, but as part of community and cultural obligations has taken on the care of a number of other young members of the extended family, cousins, and even another community child from her community under her care. And this has required some very flexible arrangements as part of the working life, and so without those flexible arrangements, and particularly around cultural and kinship care, then this member would not be able to continue to work, would have to remain home, and there would be a huge loss to public education in the state that they work, and for the team that she manages. But also, I think that I think being able to balance work and family and kinship is really important, and that's part of what the NES should be able to do for our community.
Thank you. And Darcy?
I would agree with what Michelle and Anthony have said this morning. People shouldn't have to choose between their cultural identity or maintaining their cultural identity and their obligations to family and kin and country, and whether they can continue to work. Often our members they rely on having good managers to be able to understand what all these obligations are about, what their responsibilities are. And if you have a good manager, good luck. I mean, you're fortunate, that's great. But if you don't, and if people don't have that understanding or that willingness to understand, then you're on your own a little bit, and then you have to make difficult choices, and that is not fair. Our employment framework needs to modernise to recognise the needs of the diversity of our workforce, and kinship relations are not, I suppose, your Anglo-Australian typical nuclear family and all of those things. It needs to be more expansive and inclusive.
Thank you. Do you have a question there? No. Ms. Roberts or Ms. Lawrence, do you have any questions?
I don't have any questions, Chair, but I would like to say a big thank you to the team for the presenting and the experiences that have been through.
Thank you. Nothing from Ms. Lawrence? No? Excellent. Thank you very much. Well, I would like to thank our witnesses for appearing today. You'll be sent a copy of the transcript to request any required corrections. Thank you. Enjoy the rest of your Friday and your weekends. Thank you. Thank you very much.
Thank you. Thank you.
Thank you. Thank you. Thank you so much. Thank you. Okay, I now welcome our witness from the Australian Youth Affairs Coalition to give evidence. For the Hansard record, would you please state your full name and the capacity in which you appear?
Hi, my name is Nellie Wotherspoon and I'm here on behalf of Australian Youth Affairs Coalition. My role there is National Youth Policy and Project Officer.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that these hearings are formal proceedings of the Parliament. Consequently, they warrant the same respect as proceedings of the Parliament itself. Giving false or misleading evidence is a serious matter and may be regarded as contempt of Parliament. I now invite you to make a brief opening statement before we proceed to discussion.
Great, thank you. I would like to thank the committee for this opportunity to provide evidence to the inquiry into the operation adequacy of the National Employment Standards. Australian Youth Affairs Coalition is Australia's national youth peak body representing the needs and interests of 4.7 million young people aged 12 to 26, as well as the broader youth sector. Our members include young people and organisations that support and work with young people. AYAC welcomes the Fair Work Commission's landmark decision in March 2026 to phase out junior wages for 18 to 20-year-olds working in retail, fast food and pharmacy sectors. However, we believe more must be done to ensure young workers are fully protected. The context of our submission today is reflected in a quote from young advocate Tai Han at our recent Workplace Rights Roundtable. Quote, "As young people, we're expected to navigate systems like education or the workplace, but we're not equipped to do that confidently. We don't feel prepared, and I think it's a common experience for a lot of young people. It's important to understand that being confused doesn't mean that you've done something wrong, and it's probably the fact that the system is really complicated and wasn't built with us in mind." end quote. AAC believes that two key areas that must be reviewed to enable young people to claim their rights in the workplace are addressing young people's reported gaps in knowledge on current employment standards and harmonising minimum working ages and conditions across all jurisdictions to ensure protections are consistent no matter what state or territory a young person is employed in. Research undertaken by AAC reveals that young people feel more can be done to educate them about their rights. Our work also reveals that young people are concerned about unemployment, precarious work, rates of pay, and cost of living. As recommended in our submission, workplace rights should be embedded in the national curriculum through civics and citizenship education. This would improve knowledge and understanding before or during young people's first experiences in the workforce. Although the Office for Youth's Digital Youth Hub has improved young people's access to quality information on workplace rights from the Fair Work Ombudsman, the content remains reliant on dense text and is limited in its ability to ensure easy navigation of the scale, complexity, and variation of workplace rights across jurisdictions. Complex information on rights at work that can be difficult to access and navigate places an unfair burden on young workers, leaving them unequipped to understand, let alone challenge employers who may be engaging in non-compliance with the NES. This not only prevents young workers from being able to claim their rights afforded to them in Article 32 of the UN's Convention on the Rights of the Child, but it also erodes the core function of NES. The ACTU's 2025 analysis of ABS data revealed around 1 in 5 young workers are victims of wage theft. And with wage theft only being made a criminal offence federally in 2025, it is apparent there is a way to go to ensure young people are provided equal protections in the workplace. AAC supports Youth Law Australia's position that the current NES framework must be extended and deepened to protect young workers from exploitation, and that a statement of terms and working conditions is needed to clarify the agreed terms and legal minimum entitlements of all parties and promote compliance with Australia's federal workplace laws. In summary, to ensure the NES adequately protects young workers, AAC recommends ensuring national consistency in minimum employment age and conditions, improving civics and citizenship education to build understanding of workplace rights, making government resources about NES and broader rights at work more accessible and youth-friendly, and introducing regulated employment contracts as outlined in Youth Law Australia's submission. By addressing these issues, we can ensure that the national employment standards fulfil their purpose to protect all people in the workforce and give them the knowledge and confidence to assert their rights. AAC is currently undertaking further primary data collection for a report on workplace rights. If this fits within the committee's timeframes, we would be happy to share the results of our research with you, which will be available in late June. Thank you for listening.
Well, thank you very much. And if those timeframes work out, we would be delighted to see that information. What to you would look like an ideal program for educating young people around their rights at work?
I think to develop a program which adequately supports young people must be involved from the outset in the development of the program. So this could look like, partnering with young people in a co-design project, but ideally, it should be maybe a step beyond co-design and youth-led, because as research shows, policy which is developed with the target audience in mind, creates higher quality policy.
Great. And would you see that as something that happens in schools?
That would definitely be part of it. As we discussed in the submission, we did suggest that it should be embedded within the civics and citizenship curriculum, national curriculum, just so that, all young people have like a level playing field in terms of the information that they're provided with. But I think it's also up to the Australian government to provide young people with adequate and also developmentally appropriate information, more like socially developmentally appropriate rather than brain development or anything like that. But Yeah, it's. I think it's also the current Office for Youth digital hub. The information is, there's a lot there and it's great, but it's just quite hard to navigate. And I think it could be broken down into maybe explainer videos, shorter, social media posts. There's like a variety of ways that I think, they could make the information a bit more understandable and digestible for young people.
Thank you. And I mean, obviously, to get to the Office of Youth website and look at the information there, you've had to make a decision and know that that exists to find it. So I guess I'm really interested in what more could be done in terms of the outreach. Obviously, we've referenced the youth law submission around, contracts and information in that form. But in terms of outreach and education and helping people who might not know the Office of Youth exists, for instance, like what would that look like for young people who are about to embark on perhaps their first job?
Yeah, so I mean that's kind of, I guess, the reasoning behind embedding it within, the national curriculum in civics and citizenship education, which, isn't consistently kind of implemented across all schools at the moment. Hopefully in the future it will be, but I guess having it, through formal education is kind of one of the best ways to kind of reach all young people, including young people who might be a bit harder to reach. Other ways that this could be done would be through community youth work programs, youth clubs, youth centres. This could be a good way to reach marginalised communities, cold communities, through, local cultural centres and things like that. So, that's what I would answer.
Thank you.
Just
Any questions?
One question, Chair. I noted in your contributions today that you mentioned support around like a model terms of contract. Are you able to maybe talk through that, and what are the sort of the key things that sort of are important for young people that you support in your role?
Sorry, just to clarify, are you referring to the youth laws suggested framework?
Yeah, I just would love to hear your contributions around that recommendation.
Yeah, so the youth law contract is basically what they're suggesting is for a standardised outline of expectations from the employer to be provided to the employees like upon signing the contract, so that everything is laid out for employees, their rights and the expectations of their role, beyond that as well, the award rates, just so that the information is all kind of clearly laid out for them prior to, starting the role.
Great. Do you see any particular need for more information, or are there any gaps that you can see in relation to apprentices, for instance? Because I think we all hear anecdotally that the experience of apprentices, and we see also in data, is unfortunately not always the best, and that underpayments, bullying, harassment and discrimination are unfortunately too prevalent.
Yeah, that is something that we did touch on briefly in the submission. It wasn't so much focused on, I haven't done direct research into the bullying aspect of things, but yeah, I might have to come back to you. What I've just got what is written in the submission, which is just a short, like small bit of research. Sorry.
That's okay. It was just a question around, just in case there was anything else that I perhaps had missed. Do you think there are any particular cohorts of young people? I mean, you did mention difficult to reach young people that would be more in need of support, and I'm wondering here too if there are people where maybe English isn't their first language, where perhaps more information could be done in language to help them.
Yeah, for sure. I mean, the young or just migrant workers in general, there needs to be additional support put in place for migrant workers, just, language wise, and also, cultural, sensitivity wise as well. Young people from who might be from out of home care backgrounds, disabled young people, these groups all need specific supports put in place to help them understand their rights. And when, it's already hard enough to navigate the kind of patchwork of legislation across the country, I can't even imagine, having additional barriers which might, make that even more difficult. So, yeah, there has to be, in any kind of programs which are developed to support young people, those more marginalised groups definitely need more tailored support.
Thank you. And I imagine, you're doing more research, so there'll be more information that comes to light. But in terms of the areas that young people are most concerned or have experienced non-compliance, are there particular areas that do come up more often than others in relation to the NES?
We don't have specific data at this point in time on that, but I think the majority of young people that we've spoken to and the topics which were discussed in the roundtable that we held last month, I think one of the main concerns was just the lack of understanding and the complexity of the standards, and also just understanding where exactly to get the information. A lot of young people reported not kind of having to learn as they go and gather experience that way, or through parents who might be employed or older people around them, and they voiced that was unfair and that they shouldn't kind of have to be starting on the back foot, and they should have all the information provided to them from the outset. But yeah, in terms of specific, young people facing harms in the workplace or breaches of their rights, I don't have specific information at the moment, unfortunately, but hopefully, or not hopefully, but I will be able to provide you with more data when our report comes out.
Well, thank you very much. We look forward to that. Any further questions?
Nothing
No.
further.
Well,
Thanks, Chair.
No, thank you so much for your submission. Thank you for joining us today. We really appreciate it. As I said, we're looking forward to seeing what further data your research is able to bring to light for this committee to consider. And enjoy your weekend. You'll be sent a copy of the transcript to request any required corrections.
Great. Thank you so much.
Thank you. And on that note, I declare this public hearing closed.